Achha, we'll take up mentioning from that side, one of the sides, so that there is no junior seniority. I mean, there's complication on that. So from the left side, please. Yes. Matt appeal. Matt appeal, I mean, we would be able to take up. Is there after single matter appeal? Ache ki list hai dekhe list.
A lot of matter appeals are there.
No, inclusion is unable to. No, shunbo na. It is list anan. Very well. Please hand over. Yes. Hand over. Yes. Hand over. Yes. Yes. Next, please. Hand over. Yes. Urgency. All the matters are urgent. No, we are sorry. No upgradation right now. All of them apparently are. So no, please don't. No upgradation. Right now, no. We'll definitely consider that. Let us just start with the matters, then we'll evolve our system. Yes. Second appeal. Order 41 is mandamus appeal. No, only the order 41. No, not so many mandamus. We cannot hear it out. Yes. Hand over. Hand over. Your quota is over. Why? Leave is granted. No upgradation right now, ma'am. I'm sorry. We are sorry. Same bench is not there, so we cannot. I mean, there's no urgency in on that count. Next, please. No, nothing. He's there. Upgradation, no. Yes.
By order dated 25th of August 2023, but due to financial tendency, could not able to furnish the bond. He's still in custody. If your lordship kindly takes up the matter.
Still appears to be mentioned tomorrow. To be mentioned to Calcutta. 235 will appear as to be mentioned. Please write it on a slip of paper so that there is something on record. To be mentioned tomorrow. Inform the state also. Yes.
Addition to the CBI, you will not see for investigation on certain point. Now you will not see the final investigation report is completed and you will not see ready for further consideration. So kindly make
inclusion in the list. Hand over. Yes.
Two mandamus appeals. These appeals are defective. These need to be withdrawn and filed afresh.
Those will appear as to be mentioned whenever the file comes. If it is there, it will appear tomorrow. To be mentioned tomorrow.
Lordship. Grateful, Lordship.
Thank you. Yes, please. Yes, Mr. Hapudda.
In connection with appeal 2 and 3 restoration of bail application and bail application to bail application. Inclusion in the list.
Very hot.
Also, I'm praying for listing new appeal, my lord. Group for new appeal, my lord.
Appeal, not right now.
Mandamus appeal, my lord. Your lordship.
Yes, mandamus appeal. One of them we did include. No further appeal. Try your luck in the next. No, not right now.
Due to some departmental file.
Not right now. Not right now.
Another 2 matter, my lord.
What are those?
Another 2 matter is, my lord.
Be quick. Yes, we'll start the matter.
Challenging the order of the tribunal.
Give one. Choose one of the matters and give one. Yes. Give one. Yes. Next, please. Hello. Correction. Whose order?
Correction of
correction has to be done by that bench. You have to mention before the. I mean, it has to go there. We cannot correct their order. Correction we cannot.
The correction in the cost title.
Even then we cannot. Theoretically we cannot. But put it as to be mentioned. They'll put it on the list as to be mentioned. The correction don't have hand over. The others, please. Yes.
There is correction in appeal. Lordship, the petitioner is the father of the fourth.
Hand over.
Lordship, the matter was running in the list yesterday, but today it is not running in the list, your Lordship.
Now it will work.
Kindly,
Yes.
your Lordship, the mother of the petitioner is in hospital, your Lordship.
For inclusion in the list.
What is the matter? Not first appeal, not right now. Tender of first, what is tender of first appeal, sir? First appeal, it's a first appeal for all. Is there any connected application? Then it has to be the hearing of the appeal. It has to be civil first appeal. Motion, there is no motion in civil first appeal. It is deemed that the registrar admits, it will be hearing. First appeal admission is not necessary. We don't admit in. Very well, let this appearance to be mentioned tomorrow. It okay to be mentioned. Yes.
Millard, one.
Yes, Mr. Ghosh.
Millard, one mandamus appeal, Millard, I would have troubled your lordship, but a running business has been shut down, Millard.
Mr. Ghosh, we have allowed 1 or 2 weeks. There's no use, I think.
Millard, a running establishment has been shut down. for-
Not right now, not right now. Mr. Ghosh, we are sorry, no. Yes,
Millard,
yes, hand over.
Lordship, I'm carrying the reports that the mother of the petitioner needs a cardiac surgery. It's a very.
Which one?
The matter I have mentioned.
Did it appear in the list? We will consider the urgency if necessary.
can you use the liberty to file the bail application without the certified copy of the order?
You have got server copies?
Yes.
Hand over. Yes, leave is granted. No further, no. Only what is only? Very well, hand over, hand over. Yes, sir.
Lordship, one liberty. My colleague had mentioned one matter, but just to Abu Islam. My lord, your lordship was already allowed the mentioning.
Yes.
My lord, I only pray that if.
Oh, that matter. Yes, what do you pray? What do you ask for?
My lord, the report is with us.
Yes, he
My lord.
did I refuse?
No, no, no.
Yeah.
My lord, if your lordship is pleased, have to put it more at the fairly top of the list.
Tomorrow we can't assure you. So let us.
Submit a report. DIG, we have called the DIG from Delhi.
Very well. Just hand over the that slip again. It to be mentioned. Double हो जाएगा किंतु. Very well.
Careful, ma'am.
Yes, sir.
Mention for 1 second.
No, order 41 has to be yes. Very call on the list. একটা ই মেনশনিং আছে একটা না অনেকগুলো ই মেনশন বাদ দাও চলো কল কল লিস্ট ফটাফট ওই বেল গুলো দিচ্ছি চল কল কল yes 1
I'm appealing for the,
yes
if the petitioner was granted interim bail
it is appearing you're there yes
for 12 weeks on medical ground. The petitioner is suffering from brain tumor.
brain tumor what was the offense
Offense, Lordship, 280 grams heroin was recovered from the possession of the petitioner.
so what do you want now
My instruction is that.
but the ground you are pleading then it has to be extended indefinitely then that will amount to a regular bail.
Lordship, there are other grounds also.
What are you asking for actually? The extension of that interim bail?
Lordship.
What are the other grounds?
Other grounds, 41B is not complied, Lordship. Memo appearance does, column 10 of the memo appearance is blank. That is the one ground.
The presumption is for 41B.
Extension was spread.
But this just to show আপনার yes
Another ground is that extension was spread solely on the ground of FSL report. And after the judgment of.
yes what do you say to this sorry yes
Commercial quantity of heroin, my lord, recovered from the position of the disputed.
section 41B what about that
It is not, column number 11, it is not blank.
not blank
10.
10 10 10
Take out the blank.
Witness signature.
Witness signature.
who has brain tumor The lady, the petitioner herself. What about treatment of a child? Something was recorded in the previous order.
Yes, Lordship.
Child required immediate
Suffering from
fever.
disease, Lordship. I don't have the exact instruction.
Why should he extend it? I mean, she was only in custody for 5 months.
My lord, may I, my lord?
Yes.
My lord, while granting interim bail, my lord, on the earlier occasion, the honorable coordinate bench, my lord, passed on direction, my lord,
Yes.
to file a, my lord, report with regard to the, my lord, the status of the treatment. The bail was, my lord, extended till, my lord, 12 weeks, my lord. So, my lord, let the, my lord, my humble submission is, lord, before your lordship, my lord, let them produce, my lord, the medical report of the, my lord, what is the status of the, my lord, the accused.
Yes. What do you say to that?
Regard to the,
Kindly adjourn it for 2 days in the meantime. Take instruction.
Very well. At order. The petitioner seeks an extension of the interim bail granted video order dated June 16, 2023 and submits that the physical condition of the petitioner and her child are worth extension of the bail. Whose next para, learned counsel appearing for the state points out that there was a provision in the previous order directing the furnishing of a report as to the status of the medical condition of the petitioner. Full stop. In the absence of such report, comma, it is submitted that the matter ought not to be taken up. Full stop. Next para, learned counsel for the petitioner seeks 2 days time to file such report. Full stop. Accordingly, the matter is adjourned till September 14, 2023, when it will be placed fairly at the top of the list for filing of report by the petitioner and for passing further orders. Full stop. A copy of the said report shall be handed over to the learned counsel for the state in advance. Please hand over a copy to them also in advance. Thank you. Thank you.
Complete file. Complete. It's a good petition.
পরের দিন next.
I'm waiting for the petition.
Petition.
Statement. It's a case under section 302 and 200.
How long in custody?
My lords, I'm in custody since 23rd of May 2023. Charge sheet has already been submitted. My lords, kindly, I request my learned friend to hand over the case diary and kindly seize the charge sheet.
আর একটু খেয়াল রাখতে হবে তোমাকে।
My lords, when
Criminal
it comes to
bench
the charge sheet
Yes.
and the findings of the investigating officer, while he concluded the.
Please, just point out the charge.
My lord, may I hand over the certified copy of the charge sheet?
Yes. Yes. আপনি কি ফাইলটা দেখবেন একবার টোটাল ফাইলটা? দেখুন। Yes, what do you want to say?
My lords, 2 or 3 lines from the top. Kindly peruse them.
After one, okay. Yes. Well, both of us. Yes.
The petitioner before your lordship
Yes.
was arrested from Jammu and Kashmir. The entire case of the prosecution is depend upon the circumstantial evidences. One dead body of a female has been found in the field. The Panchayat Pradhan has been informed and he lodged the complaint. Subsequently, the doubt raises the identification of the dead body. Who is the female? The investigating officer says after a lapse of 2 months, the dead body of the victim has been identified by the husband of the victim as well as the son of the victim. I have been arrested from Jammu and Kashmir. I was working there. I was not present on the date of incident, that is 4th of March 2023. Secondly, the investigating officer, he was present at the time of postmortem when it was conducted by the postmortem doctor. It never happens because there must be an influential part on the part of the investigating officer. Why he was present, he did not explain so.
You are in custody for how much? How long?
My lord,
You
since
said 23 March.
23rd of May. 23rd. Charge sheet submitted.
Let us hear this state. Yes.
What happened, my lord? My lord, the dead body of the deceased victim, my lord, was found in a mutilated plight, which was lying in a field, my lord. The mouth, the portion of the mouth and the my lord, eye was completely brutally my lord, disfigured. Now, my lord, the investigating authority at the initial stage were in a complete dilemma with regard to, my lord, the real perpetrator of the crime. Now, my lord, the photograph of the deceased victim was published. Thereafter, my lord, all on a sudden, my lord, the deceased victim's son and, my lord, the husband was, my lord, traced out. They, my lord, filed a complaint, my lord. The fact reveals that, my lord, the deceased victim has a, my lord, illegitimate relationship with this particular petition. Now, my lord, thereafter, my lord, with regard to, my lord, the complaint of the deceased victim's son and husband, my lord, this particular petitioner has been traced out from the state of.
What is there to directly connect him with the?
My lord, the CDR, my lord, this case call record data reveals that, my lord, at the place of occurrence, my lord, at the crime scene, my lord, this particular petitioner was, my lord, present. And, my lord, so far the 160 judicial statement of the, my lord, son and the husband of the deceased victim, it clearly reveals that, my lord, this particular petitioner had an illegitimate relationship.
Illegitimate relation we can understand, but how does that connect him to the murder?
My lord, the call record.
There is nothing to directly. And charge sheet has been filed
Charge
already.
sheet has been filed, my lord. My lord, there are.
He is a resident of Jammu and Kashmir or
No, my
here?
lord. He is a resident of, my lord, the district of Coach Bihar.
So if he put in the usual clauses.
Arrest, my lord, fled away to Jammu and Kashmir. And, my lord, tracing out the.
He had an illegitimate relation with the lady, one. Secondly, he is a resident of Coach Bihar. Apart from that, what is there to connect him with the murder?
My lord,
I mean, prima facie. These are all prima facie.
My lord, the judicial statement.
Just because he had an illegitimate relation, you say that he had
No, my
murdered.
lord. The judicial statement clearly reveals that, my lord, with regard to, my lord, that relationship, my lord, the husband and, my lord, the son of the deceased victim, my lord, left them. There was a chaos, my lord. They were.
They hadn't even lodged a any diary after she was missing.
Kind of on page 67. Of
They
the
found out only when it was published.
Lord,
Did they lodge any complaint before that?
my lord, thereafter, my lord, they have been found,
No.
found that, my lord, the deceased, after, my lord, hearing, my lord.
So what about the fact that the charge sheet has already been filed?
My lord, after, my lord,
We shall put in the restrictive clauses. He will be in Coach Bihar within the trial court zone and attend trial. If that is there, what is the difficulty?
Record data, my lord, the in short, my lord, CDR. Call record data, my lord, clearly reveals that, my lord, at the crime scene, my lord,
Yes.
this particular petitioner was present. And with regard to, my lord, that relationship.
What was the motive?
My lord, motive was, my lord, to suppress, my lord, this relationship, my lord.
Motive of the murder.
Motive of the murder. This is the modus operandi, my lord.
To suppress the relationship.
Suppress the relationship, my lord. And, my lord, in order to, my lord, eliminate him from the world, my lord, this crime has been perpetrated by this particular petitioner. And, my lord, the circumstantial.
A bit far-fetched for the purpose of bail, at least.
My lord,
And we cannot go into trial questions.
He is the sole perpetrator, my lord.
He's a sole scapegoat.
My lord, if he is released on bail, my lord, entire trial will be vitiated.
Why?
There
How?
is no one behind the crime, my lord. Save except this particular petitioner.
If he is released on bail, how will it vitiate the trial?
My lord,
What will he do?
my lord, the police have, my lord, arrested him from the state of Jammu and Kashmir.
We are not saying that he can go scot-free.
My lord,
There will be riders.
prosecution.
Charge sheet has been filed, I
My
don't
lord,
think.
the prosecution presume that, my lord, if he is released on bail, my lord, the
nexus is a bit vague. The proximity of the nexus is a bit vague.
My lord, in the course of trial, my lord,
Definitely, if it was found on this site, then you could have the better.
kindly consider. But in the course of trial, the entire sequence of events, my lord, with regard to establish the circumstantial.
He will attend every day of trial, he will not leave the territorial jury.
That, my lord, release of his bail, my lord, will vitiate the entire trial. Because he is the sole, my lord, the perpetrator.
What is the stage of the trial? Charge sheet file.
My lord,
Charge sheet has.
next date is fixed for, my lord, production, my lord.
Yet not.
My lord, he is the sole perpetrator, my lord.
Copies have
If
not
he
been
is
served.
released, my lord, the entire trial. will
He is
be
not released. Released on bail. I mean.
On bail, my lord, on bail, my lord. If he is released, my lord, entire trial will be vitiated.
Trial issue.
He will flee away to another state.
Jammu Kashmir. Second
Circumstantial evidence, my lord.
আর তাছাড়া এইখানে পটে কেউ দেখালি কোনো আই উইটনেসি বডিটা পাওয়া গেছে সার্কিউ সার্কামস্টেন্সিয়াল বলে দিচ্ছি। You are granting. Yes.
My
The
lord, kindly
petition
consider, my lord, all the CDR, my lord, has been, my lord,
will
certified.
give our reasons.
My
The,
lord, kindly consider, my lord, the entire trial will be
the
vitiated. my lord.
petitioner submits that the
Time frame
petitioner,
schedule, my lord, to conclude the trial, my lord.
the petition does not work.
My lord.
Does
entire
not
trial
work
will
in
be
our
vitiated, my
country.
lord. He is the sole, my lord, the
The
perpetrator. my
petitioner
lord.
contends that the petitioner was apprehended in Jammu and Kashmir for an offence perpetrated allegedly in West Bengal. Full stop. It is contended that there is no direct nexus between the alleged crime and the petitioner. Full stop. Next para. It is submitted that the petitioner is in custody from May this year. Full stop. Charge sheet has already been filed. Full stop. Next para. Learned counsel appearing for the state vehemently opposes the prayer for bail. Full stop. It is contended that the petitioner has been apprehended by the police from Jammu and Kashmir and was trying to escape the crime scene. Full stop. It is further argued that the release of the petitioner on bail shall vitiate the entire trial. Full stop. Next para. As it appears from the submission of learned counsel, comma, the proximity between the alleged crime and the petitioner's alleged involvement is far-fetched, comma, at least prima facie. Full stop. Next para. First, comma, no eyewitness has corroborated the allegation that the petitioner was there in the crime scene at all. Full stop. Although the nature of crime is heinous, comma, insofar as the body was mutilated, comma, even the family members of the victim, comma, apparently had not lodged any complaint against the petitioner initially. Full stop. The only ground which seems to play in the mind of the prosecution for the present is that the petitioner had an illicit relationship with the victim lady. Full stop. However, comma, mere illegitimacy of a relationship, comma, even if established, comma, does not establish a direct nexus between the crime alleged. Full stop. Next para. Moreover, comma, since the charge sheet has already been submitted, comma, we do not find any reason to further curtail the personal liberty of the petitioner, of course, comma, subject to certain stipulations. Full stop. Accordingly, CRM DB 452 of 2023 is allowed, comma, thereby granting bail to the petitioner on condition that the petitioner furnishes a bond of rupees 20,000 with two sureties of like amount each, one of whom must be local, comma, to the satisfaction of the Chief Judicial Magistrate, additional chief, satisfaction of the additional Chief Judicial Magistrate, comma, Dinhata. Full stop. The petitioner shall not leave the territorial jurisdiction of the trial court during the entire period of trial and shall attend each and every day of trial. Full stop. Moreover, comma, the petitioner shall not make any inducement, threat, or promise, comma, directly or indirectly, comma, to any person acquainted with the facts of the case, so as to dissuade such person from disclosing such facts to any police officer or the court, and or tamper with evidence.
May I suggest one thing?
Yes.
My lord, if he fails to attend the learned court below during the course of trial in a single date, my lord, his bail may be, my lord, rejected, my lord.
Automatically,
Or let there be a prediction, my lord.
there may be several circumstances why he may not reach. Several circumstances. That is the difficulty. We have to keep some laxity for the happenings which may occur in our country. I mean, have to be practical also. I can appreciate your agony, your apprehension, but nexus, we don't want. Yes. Doc- Yes. 3,
Lordship, I'm for the petitioner, praying for not to do your lordship.
not today. No.
My lord,
Yes.
my lord, if your lordship is kind enough to fix it on Thursday, my lord.
This matter, the previous one, Thursday. Very well. আগেরটা তাহলে Thursday করে দাও।
Okay, in this matter, I'm praying for one time.
One day. Not-
My lord, if I am permitted, my lord.
Thursday.
Thursday, my lord. Mr. Shahapur has another matter before this court. So both of them are connected. So-
Yes, some 100 matters.
No, no, my lord. More than 100, my lord.
Before that. So Thursday, this also Thursday, so very good, Thursday or Thursday.
Item number 13, my lord.
Item number? Whatever item was called, Thursday you say. Five, yes,
With your leave, my lord.
please. 5 who is appearing? Yes.
Not to your lordship.
Why? You move not.
Lordship, I have been instructed from the advocate on record for not to bring for not to your
He
lordship.
has got a good case or a medium case or a bad case.
Medium case.
Come back tomorrow. Very good. Not. Yes, please.
Sam Patel.
Yes.
Lordship, the case has been initiated
Hmm.
under section 3, 4, 5 and 10 of the Official Secrets Act. Here in this case, your lordship,
Official
Secrecies Act.
secrecy. Oh, yes.
Your lordships, the petitioner is detained in custody since 21st December 2022. Lordships, the one Visheshwar Sarkar. the
Allegation is
inspector-
serious.
Lordships,
How long are you in custody? Serious in the sense regarding bail.
yes, your lordships, I am coming on that point. This is my allegation. This is the allegations made by the escape who is made the complaint.
If you are released, then Pakistan may win the next cricket match. There is very serious apprehension. Yeah.
Lordships, I am coming to that point. Your lordships, first thing is that the charge sheet has been filed.
Right.
Question is over. Now the legal question is that whether this court, lower court, while the case is pending, the trial will be initiated or not, that there is some restriction is there.
Yes.
For the provision of section 13 of the act, 13(3) of the act,
Hmm.
your lordships is to be considered, no court shall take cognizance of any offense under this act unless upon a complaint made by the order or under authority from or some office empowered by this on this behalf. So there is a restriction for initiation of the trial begin by the learned court. Now,
It is then-
lordships, yes,
Please hand over a copy of that.
13(3).
Thank you.
Lordships, in that case, your lordships is to be considered that during the court, after the completion of the investigation, lordships,
Yeah, we are sorry.
yes, 13.
13.3, let us first. Yes.
And this court is lying vacant now. So there is no questions for immediate trial. Lordships, another thing is that there is an allegation. It's true that the allegation is serious in nature, but question is that after the completion of the investigation,
Hmm.
investigating officer submitted a charge sheet. And charge sheet, it reveals that the very vital part of this charge sheet is that
Hmm.
the documents which was seized from my possessions, and because of this, the STF had been to my house, issued
Hmm.
notice under 91 of the CRPC. I complied that notice into appear before this investigating officer.
Yes.
And thereafter, some documents has been seized. And the mobile phone and others data were seized, which is the crux of this matters to involve me in connection with this.
Why should you grant you bail? Give me one good reason.
That report has not been sent. And without any official report from the concerned authorities, charge sheet has been filed only to detain me behind this one. And this petitioner is the man of a Siliguri.
Man of?
Siliguri, a Toto rickshaw driver. Your lordships, another thing is that, your lordships, that charge sheet, as the charge sheet is filed,
Hmm.
there is no chance for immediate trial. If there is some restrictions and for granting bail, then I think the prosecution will not be hampered. Because of the fact, only one thing is that some money's transaction, that is 84,000 in his account. Only one thing, during the course of the investigation, the investigating officer only submitted charge sheet that one transaction is made through another lady, that is the Indian who is residing at the Patna and on the spot.
Sufficiently incriminating. Sufficiently incriminating. You are giving the grounds for your arrest, actually.
Lordships, 120B is there. Only one accused is there. Nothing is there. Why how investigation?
Let us hear them. What do they say? Yes, yes, you
Sir,
say.
I'm a custody lordship, charge sheet has been filed. There is no chance.
Yes, yes, you said that. Yes, right.
Lordship, rightly pointed out that Pakistan will not only win and rain will not.
Not that, but charge sheet has been filed. What is the apprehension?
But Lordship,
What is the apprehension?
this is a case where
only filing of the charge sheet will not suffice his bail, as because after getting the information, he was arrested, his mobile was seized, it was scanned, WhatsApp messages were found, WhatsApp were contacted, WhatsApp company, and it has been revealed that connection with this petitioner and Pakistani spies through another lady, several transaction was money.
We are refusing. Sorry. Learned counsel, for the petitioner contends that the petitioner is in custody for quite some time and the charge sheet has already been filed. Push up, it is contended that the alleged nexus between the petitioner and the alleged crime is remote. Push up, next para. Moreover, comma, it is argued that since the charge sheet has already been filed, comma, there is no impediment in releasing the petitioner on bail. Push up, next para. Learned counsel for the state opposes the bail and submits that incriminating materials were obtained from the mobile phone of the petitioner as well as from the custody of the petitioner. Push up, next para. Considering the nature of the allegations under the Official Secrets Act, 1923, and the apprehension that the petitioner might engage in similar activities if enlarged on bail, the mere fact of charge sheet having been filed does not suffice to dispel the presumption in the present case. Full stop, next para. Hence, since the enlargement of the petitioner on bail may cause apprehensions of the trial being influenced, we are not inclined to grant bail to the petitioner. Full stop. Accordingly, CRM DB 476 of 2023 is dismissed. It is expected that the trial of the petitioner be expedited as far as possible. Thank you.
Civil Miller, I am appearing for the state.
Right. For it ready record.
Well,
Yes.
kindly comes to the 2 pages back from your lordship's brief. It's order date, order number 30, dated 3rd of May 2023.
2 pages back means?
The order number 30. Initially, the case has been registered, the cognizance has been taken by the special court. Subsequently, a revision has been filed and lordship, the order has been passed. And it has been stated that the entire prosecution case should be tried by the magistrate. It has been remanded back to the ACJM for taking cognizance afresh, and it should be sent to the.
What is the ground for bail?
My lords. Charge sheet has been submitted. The allegation against the petitioner that few ATM cards have been seized from the petitioner. They were intercepted in the ATM counter with 2 other accused persons. From one accused person, 40,000 rupees has been seized. Another accused person, he has fled away, he is still absconding. From my possession, few ATM cards have been seized.
How many?
Around 40.
Total 63.
Only 40 ATM cards.
Total 63.
You should be immediately released and acquitted. 40 ATM cards, you don't have any status at. Why should we grant bail to you? No.
I was not using those ATM cards.
No.
My lords, kindly consider.
You are a curio collector. ATM cards, 40 ATM cards, how do you explain that?
My lords, kindly consider one. It's a magistrate trial. Maximum punishment is of 7 years. And there is a rare chance of the trial should be initiated as early as possible because one of the accused person has been absconding until unless he has been arrested. The trial won't start. This is the usual practice.
Charge sheet has been filed.
Charge sheet has been filed.
What is the stage of trial?
Now,
One
production. Just
may I, my lord?
report.
I'll just come to you. Yes.
Report to be filed for the execution of warrant against the.
So let us say the state. Yes.
My lord, total FIR named accused was 2.
473
But charge
days
sheet
I am in custody.
3 accused persons against 3 accused persons. 2 are already in judicial custody and 1 person still in still absconding, your lordship. This is the present status. My lord,
Charge sheet has been filed. He's in custody for 473 days or something like that.
my lord, yes,
More than a year.
That's true, my lord. Kindly see the FIR, my lord, and then the flag, yellow flag page. My lord. Kindly see the FIR.
The Lordship will find from the charge sheet that no 164 statement has been recorded. The entire prosecution cases depend upon the 161 statements.
Yes, he's already in custody for 473 days.
My lord, 63 ATM cards recovered from this.
No, we have no doubt on that. I mean, you have a very strong case against him, but the trial is going on. Let him not leave the territorial jurisdiction of the trial. These accused কোনোদিনই ধরা পড়বে না, ও তো সারা জীবন তাহলে জেলে পড়ে যাবে। করেছে অফেন্স তো করে হয়ে গেছে, কিন্তু 473 days trial হয়েছে বেরার অ্যাবসকন্ড করছে, হ্যাঁ কবে পাবে কোনো ঠিক নেই। হ্যাঁ ছেড়ে দিচ্ছে condition this right. We are granting. Learned counsel for the petitioner contends that the petitioner is already in custody for
473 days.
473 days. Full stop next para. Further, comma, charge sheet has already been filed and it is uncertain as to when trial will begin, comma, since one of the co-accused persons is absconding. Full stop next para. Learned counsel for the state opposes the prayer for bail and submits that the petitioner was found in possession of several ATM cards and the charge is prima facie strongly established against the petitioner. First up, be that as it may, comma, we find that the petitioner is already in custody for 473 days and the charge sheet has been filed. First up, hence, comma, there is no reason for further incarcerating the petitioner till the trial is over, comma, more so since one of the accused persons is absconding and it is uncertain as to when the trial shall be concluded. Full stop next para. Accordingly, CRM BB 478 of 2023 is allowed, comma, thereby granting bail to the petitioner on condition that the petitioner furnishes a bond of rupees 10,000 with 2 sureties of like amount each to the satisfaction of the jurisdictional court, which is the special court, EC Act, come additional district and sessions judge, second court at Kuch Bihar. First up, the
ACJM
I'm sorry, to the satisfaction of the ACJM Megliganj. First up, the petitioner shall not leave the territorial jurisdiction of the trial court during the entire period of trial and shall attend each and every date of trial. First up, the further, comma, the petitioner shall not usual make any inducement, threat or promise.
Yeah.
Thank you. এইটা একটু অরিজিনাল সাইডের ওদেরও শিখিয়ে দিও ইন্ডিউসমেন্ট। For a problem আগে ছিল ঠিক আছে, একটা ইজি হয়ে যায়। হ্যাঁ ঠিক আছে। না আপনি জানেন।
Lordship, item 8, I'm praying for 1 day's accommodation.
Not today. Not today.
Yes.
Right.
Tomorrow, Lordship.
Not today means tomorrow. Oh, yes.
99 for the petition.
Yes.
But 6 and 7 of POXO Act.
6,
And section 6 and 7 of POXO Act.
section 6,
6 and 7.
6 and 7 already, yes. I was wondering whether there is any 67 in the POXO Act. That's why yes, 6 and 7 of the POXO Act, yes.
But charge sheet also filed.
Presumption is against you. Why should you dispel that?
So, my lord, I am saying, my lord, this court to take a judicial notice of the fact that, my lord, the age of consent is not the age of marriage, my lord. I am 17, the victim girl is 17 years old and 4 months. When she can.
You are?
I am, my lord, 21 years old. My lord, my only fault is, my lord, that I fell in love with someone who is not 18 years old and just 2 years younger than me, 3 years younger than me, actually. But the age of consent may be barred because, my lord.
At the time of the alleged offense, you were 17 years, 4 months.
Yes, 17 years old.
And how long are you in custody?
107 days.
From the 161, 164, anything, is there any indication of romantic affair?
Yes. Critical.
Your silent means there is.
Now the next page, the reverse.
She was pregnant.
That is the reason. Pregnant with a case খাইয়ে দিয়েছে।
After 6 months, the complaint was made for pregnancy, my lord. It was consensual relation, my lord. In the adolescence period, the valor of exploring sexuality is a very high risk case.
She was pregnant when the complaint was lodged.
After 6 months, my lord.
After 6 months, my lord, she was there's a medical, my lord.
At the point of time when the complaint was lodged, was she already pregnant?
Yes, yes.
That has not been detected because medical.
How long after that it was detected?
Medical, my lord.
How long after that? Approximately
Medical.
6 months, my lord.
6 months from the complaint.
Yes,
No.
no, from the pregnancy, 6 months. My lord.
Medical is in page number 1819 where it was.
Complaint is lodged today. How long after that was the pregnancy test held?
My lord, the incident happened prior, long back from the.
So will grant. Learned counsel for the petitioner contends that the petitioner is already in custody for more than 100 days. Full stop. Next para. Moreover, comma, there is sufficient material to indicate from the statements of the witnesses that there was an amorous relationship between the parties. Full stop. The victim was about 17 years, 4 months at the relevant point of time when the offense was allegedly committed. Full stop. Next para. The petitioner, comma, it is noteworthy, comma, is around 21 years old. Full stop. Next para. Learned counsel for the state opposes the prayer for bail. Full stop. We find from the materials that the petitioner, the victim was pregnant, comma, which was detected near about the time of the complaint. Full stop. Next para. There is sufficient material to indicate that there is an apprehension that the relation was consensual. Full stop. Moreover, comma, the age of the victim was borderline, comma, bordering on majority. Full stop. Thirdly, comma, the pregnancy subsequently might have been an determinant of the complaint being lodged against the petitioner. Full stop. In view of such mitigating circumstances, comma, we are inclined to grant bail to the petitioner, comma, since in our opinion, comma, the petitioner is entitled to personal liberty, having been in incarceration for quite some time. Full stop. Hence, CRM DB 482 of 2023 is allowed, thereby granting bail to the petitioner on condition that the petitioner furnishes bond of ₹10,000 to sureties like amount each to the satisfaction of the special court POXO at Jalpaiguri.
Yes, my lord.
Bhaktinagar. Oh, no, I'm sorry. Jalpaiguri. Jalpaiguri, special court, POXO at Jalpaiguri. Full stop. The petitioner shall not leave the territorial jurisdiction, usual. Shall not leave, attend each day of trial, and shall not make an inducement thereto. Thank you. Two sureties, one of whom must be local, usual jet. Yes. Next matter. Short passover very well.
Well, my lord.
Then we'll take it up tomorrow. Tomorrow. I mean, it will be uncertain otherwise. Tomorrow. Very, not today.
Item number 11, praying for 1 week adjournment because this is a POXO case, but copy has not.
Whatever reason, adjourn for the week, next week.
Item 12.
I am for the statement.
Yes.
I'm paying for 1 day.
Why?
That's 1 day.
Not today. State is present, you are not moving matters. Bail, anticipatory bill. Anyway, next.
Item 13.
Same.
No, lordship.
You want to move?
Lordship.
State is not there now. What is the matter? Let us start. Let us see whether the state. Union of India is that.
Should then make it pass over.
Pass over. Very well.
But I am for the petition.
Yes.
But this is a POXO case, Lord. But offense under section 363, 365, 109 of the Indian Penal Code
and read with section 6 of the POXO Act.
Your age?
My age is 20 and my the victim girl age is 15 plus. And my lord, charge sheet has been submitted.
You're opposing?
No, my lord, actually there is a relationship.
15 is too young.
15 plus, my lord, 15.
I don't, we don't want to put in our idea, but I mean, not bordering on majority. Anyway, those concepts are being considered now worldwide.
Charge sheet submitted 100.
Charge sheet submitted.
100 and
Submitted, my lord, on 27/6/2023, my lord. What is the case is, my lord?
How long are you in custody?
106 days, my lord.
Yes, what do you say?
The fact of the case is, my lord, that she was kidnapped on 25th of this March, my lord. After that, my lord, after 2 days recovery, my lord, this complaint was lodged, my lord, by the de facto complainant of the father, my lord. That is the 164 of the victim, my lord, where she clearly states that this accused, my lord, ravished her. And
Stage of trial?
Stage of trial, my lord, charges.
Only charge sheet submitted. my lord. But this petitioner wanted to marry her, my lord, and they also
No,
agreed.
she alleged in her statement that you have ravished her and all this.
Yes, my lord. Out of
Anyway, several circumstances can. Learned counsel for the petitioner submits that the petitioner is around 28 years old and the victim child
20 years.
20 years old, sorry. And the victim is around 15 years. First up, it is submitted that there was a relationship and consensually the victim went with the petitioner. First up, subsequently, the petitioner was arrested and certain allegations were made. First up, however, it is argued that the ingredients of Section 6 of the POXO Act have not been satisfied in the present case prima facie. First up, moreover, the petitioner is in custody for more than 100 days. First up, next para, learned counsel for the de facto complainant, on instruction, submits that the de facto complainant does not oppose the prayer for bail. First up, next para, learned counsel for the state alleges that, submits that serious allegations were made by the victim against the petitioner. First up, next para, although the victim girl was still far off from attaining majority and her consent cannot be lent much weight, in the circumstances of the case, the petitioner is already in custody for more than 100 years and the custody and the charge sheet has already been filed. Push up, next para, that apart, there is some doubt as to whether the ingredients of sections 5 and 6 of the POXO Act were attracted, in view of there being the possibility that the petitioner did not have any positive role to play in perpetrating the offense as contemplated therein. First up, hence, we are inclined to grant bail. CRMDB 523 of 2023 is allowed, thereby granting bail to the petitioner. Usual condition: 10,000, 2 sureties, like amount, 1 local, to the satisfaction of the POXO court. Jalpaiguri?
No, POXO court, my lord, Dinata,
POXO court Dinata, or Bankita Jathai. Shall not leave, or shall attend trial. Thank you. Yes, next.
My letter, I am for the petitioner. Case under.
Yes. Case under?
My lord, I am for the petitioner, case under section 6 of POXO Act. My lord, the petitioner was custodied 31st May 2016.
7 years, 3 months, 19 days.
19 days, my lord. My lord,
Stage of trial, what is the stage of trial?
stage of trial, my lord, 2 witness was examined petitioner PW1 and PW2. My lord.
What is the apprehension?
Next, it is fixed on 16th of September. The thing is that the age is 40 years.
My lord, kindly see only one thing, the PW.
Age of the
cross examination of PW1, my lord. I have stated
is 13 years. 164, it corroborates the.
No mitigation on that ground, definitely. But 7 years in custody, that is the only factor.
2 witnesses has been examined, my lord. There'll be a speedy, my lord.
Speedy trial, definitely either way will direct.
my lord, kindly see the cross examination of PW1.
Is there any apprehension of him, issuing threats against the victim or something?
They're from the same locality. She used to call J2.
My lord.
No, we are not very satisfied on the antecedents, but regarding the period of incarceration only 7 years, and trial is going on. That is the only ground we are considering.
My lord,
within a month, within 3 months.
Trial
we
expedited.
finish, sir.
my lord, kindly see.
Already for the
kindly
last
see
7
the-
years.
the-
We'll expedite the trial. We will not grant
No,
bail.
my lord, kindly see, No, PW, mother of the victim stated, no.
We'll give you liberty to, if the trial is not completed in 6 months, we'll give you liberty. We'll record it in the order.
My lord, kindly see only the deposition of the PW1. PW1 cross examination, my lord, kindly see. Nothing is stated,
Cross-examination, what will be stated?
my lord, the envelope, my lord. Cross examination of PW2, one, my lord. Mother of the victim. Mother of the victim stated.
No, no, that's 160. Not at this stage, no.
My lord,
The petitioner argues that the petitioner is in custody for already more than 7 years. Full stop. The trial is yet to be completed. Full stop. It is argued that
my lord, kindly see.
the
My lord,
materials on record do not incriminate the petitioner sufficiently. Full stop. Next parallel, counsel for the state submits that the age difference between the petitioner and the victim should be considered, them being respectively 40 years, around 40 years and around 13 years at the relevant point of time. Full stop. Moreover, the trial is at a matured stage and ought to be directed to be expedited. Full stop. In view of the nature of the offense and keeping in view the age difference between the victim and the petitioner, even without going into the merits of the case, we are of the view that the purpose of justice would suffice if the trial is expedited. Full stop. Accordingly, CRM DB 528 of 2023 is disposed of by directing the trial court to dispose of the criminal trial against the petitioner at the earliest and make all endeavor to conclude the same within 6 months. Full stop. Next para. Liberty is granted to the petitioner, in the event the trial is not concluded within the said period, to renew the prayer for bail. Next.
But I am for the petition.
I am for the state.
Yes, what is the matter?
But offense under section 363, 365, 34 of the Indian Penal Code, and not adding section 371 of the Indian Penal Code. But this renewal of prayer, earlier this application was rejected on 6th of July 2023. Kindly see annexure P1, page 9. My lord.
How long in custody?
But I am in custody about, my lord, I was arrested 2022 May 2022, my lord. My lord, more than a year, 1 year, 4 months about.
What change has occurred after July?
My lord, only custody. My friend, but charge sheet submitted, other 2 accused person granted, 1 person granted anticipatory bail by this Hon'ble High Court. I have annexed the order. And another
The allegation is also very serious.
yes, that's true, but I am the PCO, but considering the
because but I have followed the 164 page. Kindly see the 164.
but kindly consider the mallet
very much.
mallet, kindly consider.
No.
Yes. Great.
The petitioner seeks bail, full stop. However, it is rightly contended by learned counsel for the state that the nature of the offense does not entitle the petitioner to ask for bail. Full stop. Moreover, from a prior refusal of bail to the petitioner, video order dated July 6, 2023, by a coordinate bench, it appears that the ground for refusal was the nature of the offense. That is, the petitioner allegedly induced the victim to elope with him with the promise to marry and thereafter sold her for prostitution. Full stop. Next para. Moreover, we do not find any considerable change of circumstances after the previous refusal of bail on July 6, 2023 to entitle the petitioner to renew his prayer. Full stop. Accordingly, CRMDB 530 of 2023 is dismissed. Sorry.
This is item number? Item
17, Mike bolo, Ritro, Mike bolo. No, Mike nahi na. 17.
I'm sorry, Malad.
No, it's all 17, yes.
My lord. Petitioner is a lady. Charge has been framed against her under section 365, 120B. FIR, she's in custody for 7 months. FIR and 164 clearly shows that 364 does not applicable to her, because it has been stated clearly in the FIR she herself went to a place. And again, so there were some.
The bail was rejected on the July 3rd.
Yes, my lord, there is change in circumstances. Initially, the case has been lodged under section.
You're the kingpin of a racket.
No, that is it.
You're the queen pin, actually.
That's the allegation.
On that ground, refused.
Yes. No.
You're no longer the kingpin. You have become.
There is change of circumstance.
What is the change?
Initial section is 370D, 387. But charge has been framed after this rejection, that is on 14th August, and only 365 and 120B has been applicable. His charge has been framed against. Page number.
Auditro, IPC to the
Yes.
Indian Penal Code. Out. Thanks.
Excellent.
কিডন্যাপিং কিংপিন বলছে রাখে তো কি হয়ে যাবে দেখা যায় 365 বলছে এটা শুধু ইয়ে হয়েছে 7 মাস মতো আছে
365. My lord, the thing is that in 164 is there. There also the complainant stated the same like thing happened the month before. On the complaint of that, the complaint of that day, this accused went. This accused made a complaint.
Yes.
Yes, my lord. The same like thing, I have annexed the 164, my lord. There also same thing stated. This complainant stated
376D could not be there against you.
Yes.
How could it be?
That's the
Yes, anyway, let us hear the statement. What do you say?
Page number 44, Charge frame, date of trial is fixed on 10th October, Lordship. Only 10 witness, Lordship, very short.
If 164 is, if my lord kindly go through the 164, it will be very clear.
164 to bar.
It will be very clear.
What did you? Hey, you're checked it out. আচ্ছা এটা 164 বার করে sorry.
Same like incident happened. No complaint after that. And again that.
Please.
Again.
Please. Yes.
She clearly stated on the previous month. 11 Tarikh. That is December 11. The same like thing happened. This accused call her. She went to with there herself. The how 365.
Allegation is very serious. It's we have apprehensions now.
Nothing against her.
We don't want another case to be filed against you.
Plausible that this thing happened month before. Again, she will go.
What is the stage of the trial?
Charges in frame.
Charge frame, Lordship, had up to fixed for evidence.
Is it plausible? Same thing happened on the month before that accused.
Had October fixed for evidence, only 10 witness, Lordship, very short.
Only?
10 witness now.
But she is a lady, 7 months. Just consider the 164. She herself stated this complainant. This complainant, my lord.
We will expedite the trial, whatever that means. Because 10 witnesses are there. The petitioner seeks bail. Full stop. It is submitted that the allegations against the petitioner have not been established conclusively, and the prevailing sections clubbed against the petitioner do not entitle the authorities to further incarcerate the petitioner. It is further submitted that the petitioner is a lady. Full stop next para. Learned counsel for the state opposes the prayer for bail and places reliance on the statement under section 164 of the CRPC. Full stop it is submitted that the respondent authorities that the state apprehends that if released on bail, comma, the petitioner might engage in similar action, comma, since there are apprehensions that she is the kingpin of she is the primary mover of a racket. Full stop next para. We find from the materials on record that the allegations against the petitioner are serious, and we cannot relieve ourselves from the apprehension that if enlarged on bail, comma, the petitioner might engage in similar activities. Full stop next para. As such, comma, we are not inclined to grant bail at this stage. Full stop. However, comma, needless to say, comma, the trial ought to be expedited. Accordingly, CRM DB 533 of 2023 is disposed of with the expectation that the trial shall be expedited as much as possible. Thank you. Thank you. No. Item 18. Other side is there. Whatever it is called on next. Oh, item 18, the next matter. Thursday. We'll adjourn till Thursday.
Item 19, my lord, I am appearing for the petitioner.
Yes, Mr. Banerjee.
Your lordship would permit me to appear through virtual mode, my lord.
Yes,
So
Mr. Banerjee. Yes.
Yes, my lord, the sections are 307, 325, 341. My lord, basically what had happened was a person was coming with another person, two friends were coming, 15 persons accosted them, and then they were beaten up badly. The reason is unknown. There's another counter FIR where another 15 persons were FIR. So basically what has happened is two warring groups fought with each other. 2 FIRs have been lost, but the disputes have stood settled. 60 days in custody. I'm the only person who's arrested. The FIR names that there were 15 unknown persons. I am the only person arrested. 60 days in custody, and both the parties do not wish to pursue their claims anymore. But in fact, your lordship would see in the order recorded by the Sessions Court, which is there in the last page, it indicates that vakalatnamas along with affidavits were submitted. The last page, my lord. Affidavits were submitted by the petitioner indicating that the other side did not wish to continue. The de facto complaint does not wish to continue. This was
does not wish to
continue. Nobody wants to continue. Both parties have lost FIRs. Both parties do not wish to continue further. Only one person arrested, that is me. I was paying
what
for
you say? Who is for the state?
I am for the state, your lordship. But it in progress. Charge sheet not submitted.
That is okay. I understand the submission now.
So we'll restrict him from leaving the territorial jurisdiction of the police station, and we'll grant bail.
Restricting territorial jurisdiction of police station, that will be very small. Considering
very well, the court, the jurisdictional court, then when the matter.
Shiliguri court.
Shiliguri, Mr. Banerjee.
Let me come out, then I'll come back with an application again if required.
It should be Jalpaiguri district.
Jalpaiguri, be specific on that.
District court.
Where you are a resident of which place, Mr. Banerjee? Let us see. Just check up.
I am of Sevok Road.
Sevok Road,
which is district Jalpaiguri.
Within the territorial.
I'm within Bhaktinagar, Shiliguri Municipal Corporation. My post office Shiliguri Police Station, Bhaktinagar, district Jalpaiguri.
You are district Jalpaiguri, so you will not district. Very will you restrict you from leaving Jalpaiguri district?
Makes it Shiliguri and Jalpaiguri. Jalpaiguri should suffice, I think, because the address is such, Manoj, subject to what your lordship.
What do you do for a living, Mr. Banerjee, your client?
Manoj, that I believe my junior who's briefed me would be able to say, my lord. It's a flying brief that I got. I'll be honest with your lordship. I do not know what I do for a living.
Learned counsel for the petitioner submits that the petitioner is the only accused person who was apprehended. The allegations pertain to a tussle between two warring groups. Next para. There have been affidavits filed by the complainants, indicating that they do not want to continue with the matter. Next para. In any event, it is submitted that the parties do not want to continue with the enmity among each other. Full stop. Next para. It transpires from the learned counsel for the state opposes the prayer. Full stop. It transpires that that considering the gravity of the alleged offense against the petitioner and the surrounding circumstances, comma, the petitioner is entitled to be released on bail. Full stop. Next para. Accordingly, CRM DB 542 of 2023 is allowed, thereby granting bail to the petitioner on condition that the petitioner furnishes a bond of rupees 10,000 with two sureties of like amount each, one of whom must be local, to the satisfaction of which court?
CGM Jalpaiguri.
To the
CGM
satisfaction,
Jalpaiguri, my lord.
very well. To the satisfaction of the learned CGM Jalpaiguri, full stop, the petitioner shall not leave the territorial jurisdiction of the district of Jalpaiguri during the entire period of trial, comma, as and when commences.
Well, till the end of investigation is normally what is granted, my lord.
Very well. Till
After
the end of,
investigation.
very well. Leave the territorial jurisdiction of district Jalpaiguri till the end of the investigation, comma, subject to further orders, comma, if any, passed in that regard by the trial
Deeply
court. Full stop. Next para. Moreover, comma, the petitioner shall not make
Usual
any
terms.
threat
My
or
lord, of course. Deeply obliged, my lord.
yes, de facto complaint, what is it?
Deeply obliged. Yeah.
Oh. তাহলে একটা
They're
ওই
supporting.
you should have supported earlier before Mr. Banerjee opened. প্রথম লাইনে একটা লিখে দিন যে at the outset learned counsel for the de facto complainant submits that the de facto complainant does not want to continue further with the allegations against the petitioner. তারপর যা আছে।
Deeply obliged. Deeply obliged, my lord.
Yes.
You can't hear anything. Deeply obliged, my lord. Deeply.
Thanks. Yes.
Is the renewal of prayer for
When rejected.
now, Lord, can you see the page number 12? Why my petition was at the first paragraph that has been observed by this law. Can you?
Now charge sheet has been filed.
Now, can you see what? Why my petition was rejected? Then an early stage of investigation, the investigation was.
This is an abatement to suicide. That is,
Why? Now, can you see what is the FIR? And you see the page number 9 and 10. Both of them are attended as a point. They had an intimacy. And they maybe there are some hot relation to. Can you see the FIR lordship in page number 9? The matter will be crystal clear, your lordship. I am is it about 19.
you are now 19.
19.
Yes.
Now, another thing, I was in Kerala. When I got the information of that unfortunate incident, immediately I rushed to my house and I was.
Charge sheet has been filed. Yes, what do you say?
Not yet.
Not yet.
But page 84, 164 statement of the mother of the victim and the page 94 postmortem report, madam. 84, madam, 84.
Actually, my allegation is that some altercation took place work on. And if we take a glimpse of 107 of the IPS,
মেয়েটা ফার্স্ট গলায় জড়িয়ে দিয়েছে 19 বছর বয়স বাচ্চা ছেড়ে দিচ্ছে No custodial
interrogation investigation is necessary. Do you think?
Investigation is still pending.
going on.
The
Yes.
charge sheet not yet submitted. At least at
Formally, you are opposing. Learned counsel for the petitioner submits that the petitioner is 19 years old and due to an altercation with the victim, comma, apparently the victim committed suicide. First of the petitioner has been incriminated on the allegation of abatement, but was not responsible for the same. First of that apart, comma, it is submitted that the petitioner was in Kerala at the relevant point of time. Full next para, learned counsel for the state opposes the prayer for bail and submits that the investigation is still going on. Full next para, keeping in view the tender age of the petitioner and there being some scope of doubt regarding the involvement of the petitioner in the offense, comma, we are inclined to grant bail. Full next para, accordingly CRM DB 545 of 2023 is allowed, granting bail to the petitioner on condition that the petitioner furnishes a bond of rupees 10,000 with two sureties of like amount each, one of whom must be local, to the satisfaction of the of the learned CJM Jalpaiguri. Full stop. The petitioner shall not leave the territorial jurisdiction of the concerned police station of the which police station? Of Dhupguri police station during the entire period of investigation and shall make himself available, comma, as and when required, comma, for being interrogated in connection with the alleged offense. Full stop. Moreover, comma, the petitioner shall meet the investigating officer once every month. Full stop. Next para. That apart, comma, the petitioner shall not make any inducement, threat or promise usual.
Shall make him available in each and every date of trial.
Trial has not yet begun. So as of now, per month he has to meet the investigating officer and he'll make himself available. We have put that is the first sentence. He'll make himself available for interrogation as and when required. Yes.
That got the bill now.
You got the yes. So next. Yes. Yes.
Section 6 of POCSO, my lord.
Gang rape POCSO very difficult for you.
My lord, yes. So petitioner is in custody for more than 2 years. 2 years, 7 months, not a single witness has been examined till date. The primary ground that has been cited that
What was the age of the victim?
16 years. At that time. Now, my lord, the thing is that I have annexed the order sheet after being granted bail. One of the accused has been absconded. That's the primary reason. But the thing is that several dates, for several days, no order for proclamation has been issued by the office. I have annexed the order sheet on dated. My lord, kindly. Come to page number 17, my lord. Order dated 24/11/12. It appears that the order dated 24/8/2022 has not been complied by the office. The office is directed to comply the state order immediately for issuing proclamation. Next, order dated 16/3/2023, my lord. The office is directed to it appears that in spite of the repeated orders, no proclamation has been issued against the absconding accused Sushil Ora, causing delay in disposal of the case. Office is directed to comply with the order immediately. ID necessary order.
You are not very convinced. One of the co-accused is absconding. Your age is 66. Allegation is very serious.
Yes, that is not how long this will continue. Office is not doing this full order.
What about the trial? Why is it being?
They said 29 September, production and year of WPA of the 3 accused persons. Charge has been read on 2020. Just heinous offense lost.
Yes, but he cannot be there indefinitely. He's an under trial now.
Under trial, but 2 other co-accused are still absconding lost.
Now, why 82,
WPA also paid.
why 82 has not been disciplined now after repeated direction?
This is not a in the civil lawsuit, but it's the heinous offense whether petitioner 3 accused jointly committed upon the victim. It's a very serious. On 3rd February 2020, charge has been taken. Not a single. This will continue for another case. Several days have been conducted by the. There is no fault on their part.
What is the apprehension? Because 2 years he is in custody. That is also one of the facets of the matter. Absconding, the backgrounds may be different.
They are absconding also.
Merely because co-accused are absconding, that may not be sufficient. I mean, the antecedents of them may be different.
It's a heinous offense. It's a heinous offense. And
what was the age of the co-accused who? I mean, this is a 66-year-old person. I don't know. I mean,
the local resident. Any condition because this will go on. I have arranged the order.
No, I'm sorry. He's the father. You're much younger. They cannot be there indefinitely.
Lordship, frame the schedule also.
Frame schedule, you have not yet started anything. No, we are refusing for the time being. Refuse.
It's a heinous offense, Lordship, it's a heinous offense.
Direction the immediately trial to get.
Complying with the order, my lord. Four order sheets. Even order has been passed, necessary order, necessary action will be taken still.
Good.
Because another 6 years will go this way.
No, we'll take care of that. Learned counsel for the petitioner submits that the petitioner is already in custody for more than 2 years. Full stop. It is submitted that processes have not been issued as yet, and merely on the ground that other co-accused persons are absconding, the trial is being prolonged indefinitely, thereby curtailing the personal liberty of the petitioner. Full stop. Next para, learned counsel for the state opposes the prayer for bail and submits that the offences committed by the petitioner, alleged against the petitioner, are heinous in nature. Full stop. Next para. We agree with the fact that the alleged offences against the petitioner are undoubtedly heinous in nature. Full stop. However, at the same time, we also have to keep in balance the fact that the processes have not been duly issued and the trial has not yet commenced. Full stop. Next para. The petitioner cannot be made to suffer incarceration indefinitely on the ground of non-commencement of trial. Full stop. However, since co-accused persons have absconded, are absconding, we do not find any justification immediately to grant the petitioner bail. Full stop. Accordingly, CRM DB 548 of 2023 is disposed of by directing the trial court to immediately take steps, including compliance of all due legal procedure for issuance of process and proclamation, and to ensure that the trial is commenced at the earliest and is disposed of as expeditiously as possible. Full stop. Liberty is granted to the petitioner to renew his prayer for bail in after 3 months, in the event sufficient steps are not taken by the trial court, to expedite the conclusion of the trial.
Get full, Lordship.
Yes. Mhm. Please use the microphone.
Delivery of some furniture.
Furniture shop, yes. Then
Petitioner did not deliver the furniture. And there on certain there, the petitioner called the inspector complainant, I will pay the money, rid of the money. This is the story is complete. And the inspector complainant, the petitioner went from Shimondi to Bangalore and to some places. Thereafter, in night, return Shimondi from Bangalore to Shimondi and stay in hotel and allegation of there is a relation of it.
Allegation?
Allegation of rape. And then that you are given some whatever some section 320. But during course of investigation, madam, charges were submitted 400 it will be not, it will be, not in the charging matter. And the current medical report, madam, did not support it. According to the she was given something and she was committed rape.
How long in custody?
106 days. My district consultant, there is a business report. And she went many places for several hours with me, but did not raise any protest, madam. And charges submitted.
কোনো ইনজুরি ফিঞ্জুরি কিছু ছিল না, বুঝলেন তো? কনসেনশুয়াল হতে পারে, ওর সঙ্গে গেছিল শিব মন্দিরে ফিরেছে, ইয়ে করেছে, ছেড়ে দিচ্ছে। You are granting.
Allegation of forceful penetration.
Allegation?
Of forceful penetration not there.
Learned counsel for the petitioner points out rightly that the initial allegations of forcible penetration against the petitioner have not been established in the charge sheet and or the statements under 160 section 164 CRPC. Full stop. That apart, comma, we find that the petitioner has sufficiently been in custody. Full stop. Accordingly, CRM DB 549 of 2023 is allowed, granting bail to the petitioner. Usual conditions. So if 10,000, two sureties like amount, one local, satisfaction of additional chief judicial magistrate Siliguri, shall not leave jurisdiction, attend trial, etc. Cause title, yes. We will give you liberty to amend the cause title during the course of the day. প্রথম লাইনে একটা অ্যাড করে দেবেন, as per prayer of the petitioner, the learned advocate on record for the petitioner is granted leave to carry out the necessary corrections in the cause title of the application during the course of the day. Please do it right now. Inducement threat promise ওটা থাকবে 10,000 inducement threat permit, ট্রায়াল কোর্টে জুরিসডিকশন ছাড়বে না আর ট্রায়াল কোর্টে অ্যাটেন্ড করবে। এই স্টেটাস মাধব বাবুকে একটা দিয়েছি, ওটা থাকবে। Yes.
I'm praying for not today.
Not today.
Grateful, Your Lordship.
Petitioner is
Petitioner?
custody of 2 years, 2 years, 1 month, my lord. Initially, the case was registered under section 10 of the Protection of Children from Sexual Offences Act. If you lordship kindly see the FIR, and thereafter a statement was recorded, and section 6 was added, my lord. And specific contents of that, my lord, there are 4 parts of my lord, including the petitioner, my lord. She could not identify anyone of them. Why I'm saying, my lord, there is story that section 10, my lord, only allegation of sexual assault in the written complaint specifically. There is no complaint regarding that allegation of rape. And another thing, my lord, after saying that there is a 4th person. She could not identify any one of them during course of investigation.
Age of the victim?
Age of the
Approximately
13 plus.
13 years, my lord.
No, not for other reasons. I mean, she was intelligible enough to make the complaint.
And during course of investigation, other qualities were discharged from the charge. But narration of story, my lord. For this reason, I'm saying.
So there is discrepancy, you say.
3 other qualities discharged from the charge. Only the present petitioner. And I want to attention on one thing, my lord.
এটা একটু সুন্দর বলে প্রথমে সেকশন 10 থেকে
যদি
দিয়েছে,
SSL
তারপর
report,
সেকশন 6 পসিবল পেনিট্রেশন তো কমপ্লেইন তো প্রথমেই থাকবে, না দিয়ে পরে অ্যাড হলো। চারজন ছিল, আর 4জন ছিল, তার মধ্যে থেকে 3জন স্কট ফি ছেড়ে দিল। এটা থাকেও যদি সেটা কভার আপ করে দিলে এই করেছে কিনা সেটা আর 2 বছর রয়েছে অলরেডি ভেতরে।
My lord, I've already seen that, my lord, because that is damaging, my lord. That is damaging. The medical is damaging, my lord, and he's the principal accused, and 164 is, my lord, totally against him, my lord.
Another thing.
But why was it not there in the initial complaint? Section 6 should have been the first thing in the complaint. That ingredient is not there in the initial complaint, only section 10, section 6 comes in. There were other co-accused, no, there were other co-accused persons also. I mean, how can we, I mean, why do you leave them alone? I mean, they're, you.
Because after 164, my lord, can clearly see why.
164 allegation.
That is the medical, my lord.
No, we are looking into the medical.
What? Because in this case, my lord, medical is very important. She was 13 years, my lord, she was ravished, and my lord, medical shows that sexual.
He's already there for 2 years.
Page 36 is the 164 statement of the victim, my lord.
Yes, we have to see that. 164. ইংরেজি বাংলার মতো করে লিখে বাংলার মতো করে লিখেছি ইংরেজি কিন্তু লিখে করে হিন্দি ইংরেজি হিন্দি লিখেছি এটা আপনি পড়ে নেবেন আপনার বাস What is the stage of trial? What is the stage of trial?
Stage of trial, my lord, in that particular case, diary, my lord, charge sheet has been submitted, but regarding the stage of.
She is in custody.
My lord, I handed over one.
Regarding the, my lord, stage of trial, I have to get information, my lord.
Galaxy report, my lord. Second test, last paragraph.
So, কোনটা supplementary? এটা
Second page, last paragraph, unofficial report, my lord. The possibility of the present petition or not, my lord. Unofficial report not supporting this document.
এখানে এটা বলছে সেমিন হতে পারে হ্যাঁ না থাকতে পারে কিন্তু এই 2 বছর রয়েছে সেটা একটা ভেতরে কি করবে সিক্স আছে 6 পরে ঢুকে সেটা পরে 6 ঢুকিয়েছি আমি 3 দিন গেছি একটু ডিসক্রিপেন্সি রয়েছে Learned counsel for we are granting. Learned counsel for the petitioner points out that there were discrepancies in the allegations against the petitioner, whereas initially there was no allegation under section 6 of the POCSO Act, the same was subsequently clubbed. Next para, that apart, other co-accused have been released. Next para, learned counsel for the petitioner also argues that the petitioner is already in custody for 2 years. Learned counsel for the state squarely opposes the prayer for bail and places reliance on the medical report, which indicates that there was sexual penetration. Next para. Upon a perusal of the materials handed over by learned counsel, it transpires that there is some discrepancy in the circumstances leading to the allegations. First, the offense having ingredient under section 6 of the POCSO Act ought to have been disclosed in the complaint itself, but, for some unknown reason, was not initially there in the complaint, but was subsequently added. That apart, although we find in the FSL report that there is a finding that there was no semen within bracket no spermatozoon bracket closed could be detected, the allegation of penetration finds place in the medical report. The involvement of the petitioner in the alleged offense has some doubts, for which we are inclined to grant the benefit of bail to the petitioner. Moreover, the petitioner is already in custody for 2 years and the trial has commenced. Accordingly, CRM DB 551 of 2023 is allowed, granting bail to the petitioner on condition that the petitioner furnishes a bond of ₹10,000 with 2 sureties of like amount each, one of whom must be local, to the satisfaction of the special judge, POCSO court at Shiliguri, first court at Shiliguri. The petitioner shall not leave the territorial jurisdiction of the trial court during the entire period of trial and shall attend each and every date of trial and shall not make any inducement, threat or promise usual. Thank you. We'll come back in 10 minutes for the next matter. Thank you. No. Not really.
May it please the Lordship.
Yes. Yes, please.
Millard, initially the allegation was under section 4 of the Protection of Children from Sexual Offences Act. Thereafter, your Lordship's charge sheet was submitted under section 4 and 6 of the POCSO Act. And Lordship charge was framed on 6th of June 2022, Lordship. Lordship, thereafter I had this is my prayer is renewed, Lordship. Lordship, on an occasion, Lordship, on 1st of March 2023, Lordship, I've annexed the order. It's appearing at page 16 of my application. Lordship, a time frame was fixed by this Honorable Court for completion of the trial. Lordship, that time frame has elapsed already on the 1st of September. And Lordship, again, a new schedule has been issued. Lordship, the lower court, the learned court below, Lordship, they have completely failed to comply with the order of the Honorable Court regarding the time frame. They have not concluded the trial. And Lordship, if I go into the merits of the case, Lordship, there are several discrepancies, right from the FIR till the 164 statement and as well as
Charges have not been framed as yet.
Charge has been framed, but Lordship, the trial is not concluded. I'm in custody for almost 650
No,
days,
direction
Lordship.
was to frame the charges and shall expedite the trial and conclude the same as early as possible.
Lordship, no. Thereafter, there's another order, Lordship. It's appearing at page 16.
Acha.
Lordship, it has been stated it is to be completed preferably within 6 months from the next date fixed for recording evidence without delay. Lordship is appearing at the last paragraph of the order.
That was the previous order. After
Yes.
that,
After that, Lordship, I had moved another application which I had not pressed. It was not pressed. It was withdrawn, Your Lordship. Lordship, the reason for withdrawal was that since we were close to the date of
what is the stage of the trial?
Mala 26 and 27 September 2023 is fixed for evidence.
they have again fixed, and Lordship kindly sees.
Total 11 witnesses.
Lordship
How
kindly.
many have already been examined? Yes.
Lordship kindly comes to page 47 once, my lords.
Page?
Page 47 of my application. Lordship, I'll show you the number of adjournments that have been taken, Your Lordship.
47.
47 onwards, Lordship.
My lord, one examined, my lord.
One?
Examined.
Out of 11.
Out of 11?
Yes.
Out of 11, Your Lordship. Lordship, several dates have passed. They have taken adjournments.
What is your apprehension if he's released on bail?
My lord, the
Offense is heinous, no doubt on that.
yes.
Lordship, but Lordship, the thing is, Lordship, then I have to make you go through the. Then
You are in custody since when?
Lordship, I'm in custody since 29th of November 2021. Lordship, 650 days as on date. Lordship, there are grave discrepancies from the even in the 164 statement, Lordship, with respect to the victim girl's clothes. They have also not been sent for FSL. The investigation was done in an absolutely perfunctory manner.
650 days আছে কি করবে? trial শুরু হয়ে গেছে। দুবার হয়েছে তো কতবার ছেড়ে দিচ্ছি ছেড়ে দিয়ে ইউজুয়াল স্টিপুলেশন গুলো দিচ্ছি আরো ছেড়ে যাবে না। We are granting bill. The petitioner argues that the petitioner has already been in custody for about 650 days. Who's up next para? There were previous occasions when the petitioner moved bail applications. First up, the coordinate benches directed the trial to be expedited, comma, lastly within 6 months, comma, but in vain. First up, next para, it is submitted that out of the 11 witnesses, comma, only one has been examined. First up, next para, it is further argued by the petitioner that there are several discrepancies in the allegations against the petitioner, and the clothes of the alleged victim were not sent for FSL report. FSL report. First up, next para. Learned counsel for the state opposes the prayer. First up, however, comma, we find from the records that despite several directions, comma, the trial is at its initial stages. The petitioner is already in custody for about 650 days. Hence, we are convinced that the petitioner's personal liberty need not be curtailed further throughout the trial. Next para. Accordingly, CRM DB 553 of 2023 is allowed, thereby granting bail to the petitioner on condition that the petitioner furnishes a bond of rupees 20,000 with two sureties of like amount each, one of whom must be local, to the satisfaction of
Lordship,
the
Judge Special Court under POXO Act, Second Court, Jalpaiguri.
to the satisfaction of the judge, special court within bracket POXO Act bracket closed, second court at Jalpaiguri. The petitioner shall not leave the territorial jurisdiction of the trial court and shall attend each and every date of trial, throughout the period of trial. Further, the petitioner shall not make, directly or indirectly, any inducement, threat or promise so as to any person being acquainted with the facts of the case, so as to dissuade, dissuade such person from disclosing such facts to any police officer or the court and or tamper with evidence.
Great.
এইটা হচ্ছে চ্যানেল ফরম্যাট, ইউজুয়াল বলতে এটাই হবে, আমি বলে দেবো। থ্যাংক ইউ।
I'm going to state it.
I'm for the petitioner.
Yes.
Lordship, this case registered under section 498A 304B. This petitioner is the mother-in-law, Lordship. She was behind the bar for more than 35 days. In the affair, marriage solemnized 5 years ago. There is general allegation, Lordship. There is allegation that committed suicide by consumed poison, Lordship. The principal accused husband is already in custody, Lordship.
Principal, he's in custody.
Yes, Lordship.
Yes, for
She
this.
is compelled to take in poison. Because the husband and the in-laws, within 5 years of the marriage, they torture upon the petitioner, victim girl, the disease, and ultimately, finding no other alternative, she consumed poison.
What is the stage of the trial?
My lord, CS is pending, my lord. This is the case of 1st August 2023, my lord. 161 of statement of the neighbors are there, my lord, at page 10, 11, 12, 13, and 14. The statement of the neighbors are corroborating the prosecution's case, my lord. And this is a very initial stage of investigation. So I am opposing the prayer for bail of the present petitioner.
Not right now. The petitioner, being the mother-in-law of the victim, seeks bail. The petitioner is in custody for 35 years, and it is argued by learned counsel for the petitioner that the allegations are vague in nature against the petitioner. The principal accused husband is already in custody. Next para, learned counsel for the state opposes the prayer for bail and submits that the investigation is still on.
Yes, ma'am.
That the investigation is still proceeding. Next para, that apart, it is submitted that the statements of the neighbors clearly incriminate the petitioner of equal involvement with the other co-accused. Next para, upon considering the heinous nature of the alleged crime, as well as the surrounding circumstances and the possible role of the petitioner in the alleged offense, we are not inclined to grant bail. Accordingly, CRM DB 554 of 2023 is dismissed.
I'm grateful to you.
Thank you.
I'm for the petition.
Yes, please.
Now, my lord, kindly see the FIR as per the, that is the page number 9. The alleged victim is the aged about 36 years. That has been awarded in the FIR. And we had a relationship. Subsequently, that it was discovered after lapse of 90 days that she was carrying. And then the FIR was. Now, if your lordship kindly take some pen to peruse, the forwarding report we have the only
376.
376.
Pregnant হয়ে
years
তারপর
old.
manage করার জন্য। How long are you in custody?
I am in custody in 58 days. Your Lordship.
Yes, we'll. What is the stage?
My lord, the victim girl is a mental disorder lady.
Oh,
This is the
No, no,
crux.
no, we'll have a chance of reply on this. Yes.
This is the crux point of the entire case, your lordship.
Where do you find that?
My lord,
Yes.
164 was recorded. If she stated in the 164 that she is.
my lord, kindly see the FIR, your lordship.
Yes.
What does it say?
My lord, kindly see the medical, your lordship.
If you are first referring the FIR, then say medical. And you see the 164.
Next page, your lordship.
The complaint was lodged after the pregnancy was detected.
Yes. When the family members of the victim came to know.
She's a married lady.
No.
No, neither
Not
I am
at all,
married,
not at all.
nor she is married. Not I am married, nor she is married. We had a living relationship.
What is your age?
Where do we find that she was mentally disturbed or anything of that sort? Show us.
In 161 statement of the my lord, page 6, 7, and 8, my lord.
164, I think recorded.
164 recorded, my lord, but 161 statement of family members of the victim, your lordship, page 6, 7, and 8.
Referring to 164.
No, nothing. No indication. Page 6, 7, 8 regarding her mental condition.
Lord,
Sir.
can I get back the case?
Yes, I think. It would be.
Now, there should be indication, your lordship, subject to lordship's correction in the judicial statement that she is mentally challenged. If there is any iota indication in the statement recorded on judicially, I have nothing to say. Otherwise, this is a consensual relationship. What's my humble submission before lordship?
Substantial কিছু নেই mentally ये बोला. Sir, it's consensually chance such. Stage, the charge sheet has been filed.
Charge sheet not investigation still in progress.
Will grant bail, yes. Learned counsel for the petitioner argues that the petitioner had a consensual relationship with the victim lady. Full stop. Subsequently, upon detection of pregnancy, comma, the complaint was lodged against the petitioner. Full stop. Next para. While opposing the prayer for bail, comma, learned counsel for the state alleges that the victim lady was mentally disturbed, comma, which aggravates the allegation against the petitioner. Full stop. Next para. However, comma, from the materials on record, comma, we do not find anything concrete to establish that the victim lady was suffering from any sort of mental unsoundness. Full stop. Hence, comma, we cannot rule out, comma, prima facie, comma, the scope of consensuality in the relation between the petitioner and the victim, comma, which mitigates the circumstances for the petitioner, comma, at least for the purpose of bail. Full stop. Hence, comma, we are inclined to grant the benefit of bail to the petitioner. Full stop. Accordingly, CRMDB 555 of 2023 is allowed, thereby granting bail to the petitioner on condition that the petitioner furnishes a bond of rupees 10,000 with two sureties of like amount each, comma, one of whom must be local, comma, to the satisfaction of the Chief Judicial Magistrate, comma, Jalpaiguri, full stop. The petitioner shall not leave the territorial jurisdiction of the trial court during the entire period of investigation and comma, thereafter, comma, subject to any order which may be passed by the trial court in that regard, and shall make himself available as and when required for interrogation by the investigating officer. Full stop. The petitioner, comma, that apart, comma, shall meet the investigating officer at least once a month. Full stop. Next para. Over and above, comma, the petitioner shall not make any comma, directly or indirectly, comma, any inducement, threat or promise. ওটা আগেরটা যা দিয়েছি same language এটা হবে. Thank you. Same. Thank you. Yes. Right.
Lordship, 14A, 14C, foreigner sector.
State is not appearing.
Lordship, I'm praying for a short passable, Lordship.
Bail, you also appear for the state. So appear for this person. Yes, foreigner sect.
Foreigner sector 14A, 14C, this petitioner Indian citizen, Lordship, behind the bar for more than 4 months.
If he flees the country, that will be good for you also. He was apprehended under the foreigner act. If he goes to a foreign country again, then please, it's all right for you. What's the difficulty in granting bail?
Lordship, only the Kuaku's statement, Lordship, this petitioner name transfer, Lordship, more than Lordship, page number, and it's 9, Lordship.
Possible, please ask somebody to appear. We are passing it over for 3-4 matters. Foreigner sect. Yes.
No, item number 30, my lord, kindly fixed on my lord, Friday, my lord. Can
30 ডাকো তুমি ডাকার আগে উকিলের চল কি করছো 30 why Friday আচ্ছা urgent till Friday state yes what is the matter?
The allegations under section 6 of the protection of children from sexual offences.
Mitigating circumstance.
My lord, the FIR, it has been stated that the petitioner forcefully committed the offence upon the victim girl, and subsequently the victim girl conceived and she gave birth of a child.
Age of the girl?
16 years.
You?
So, my
Your
lord,
age?
I am, my lord,
Very well.
25 years.
Mhm.
My lord,
44 years.
44 years, sorry, 44 years. My lord, Lordship kindly
Yes.
comes to the order dated 10th of July 2023, my certified copy. Lordship has got it. The certified copy of the order dated 10th of July 2023. Order number 7, Lordship.
Yes.
My lord kindly comes to the next part of the order. Letter dated 10th of July 2023. The learned defense counsel also files a petition for praying for DNA test, my lord, allegedly born during the pendency of the case. So, my lord, the petitioner is so much confident that he has not done this offense, my lord. He himself paid for the DNA test. My lord, if DNA test comes positive, my lord, nobody, God even cannot, my lord, save this person, my lord, from conviction. So, my lord, he is that much confident, my lord, he prayed for DNA test. However, my lord,
What is the stage of the trial?
My lord, charge sheet has been filed.
Your period of custody?
Period of custody, my lord, 115 days as on date.
115.
115.
Apart from the DNA test, I mean, the allegations, there are allegations against you in 161 or 161.
Obviously, my lord, he did speak, but my lord, no injury. But my lord, I am hurting on this only because my lord, he himself.
Your bail has been refused previously also.
The lordship kindly see. He himself paid for DNA test.
Bail petition stands rejected at this stage.
That is bail petitions. Several bail petitions rejected because CD was not there.
Just because you asked for a DNA test, you will be.
My lord, kindly consider if this DNA test comes positive, my lord, I will not be.
Then you will get the.
From conviction.
If it comes negative, you will get bail. We will give the liberty to you. After the DNA test, you will have. DNA test has been allowed. Allowed. What about the DNA test report? I mean. So we'll expedite the DNA test report, give you leave to apply afresh for bail after the DNA report. DNA test is your brainchild, not the victim, not the petitioners. Your brainchild, not the petitioners. In any event, he would be there behind bars. So why not get bail for a few days before? No, no.
In that case, Lordship, if your Lordship is negative, my lord, Lordship kindly, my lord, shift the matter for the next circuit, my lord. In the meantime, maybe, but the DNA test will come, my lord. Otherwise, I'll have to file again, Lordship.
That we can do. Record করে দেবো on the FAR. We'll record there.
Yes, Lord.
Learned counsel for the petitioner submits that the petitioner, to show his bona fides regarding non-involvement in the alleged offence under section 6 of the POCSO Act, has even applied for a DNA test. Full stop, next para. It is submitted that in view of such bona fides and keeping in mind the period of incarceration already suffered by the petitioner, that is 115 days, the prayer for bail ought to be granted. Full stop, next para. Learned counsel appearing for the state opposes the prayer for bail and points out that on previous occasions, similar prayers for bail were rejected. Full stop, next para. Moreover, it is submitted that there are no mitigating circumstances or change of circumstances since then.
My lord, it has not been, my lord, attached to the Honorable High Court. my lord.
We have not said that.
This is
We have not said that even. Petition is for bail. Who's the next para? As it transpires, the petitioner's application for bail was previously refused, although not by this court. Full stop. Next para. We do not find any change of circumstance, apart from the fact that the petitioner has taken the risk of applying for a DNA test, which has been allowed. Full stop. Next para. However, mere prayer for DNA test does not alleviate the circumstances of the petitioner otherwise, unless, of course, the test results come out in favor of the petitioner. Full stop. Hence, on the prayer of the petitioner, the matter is adjourned till the next circuit. Full stop. Leave is granted to the petitioner to move the present application for bail upon receipt of the results of the DNA test. Full stop. Next para. It is expected that the authorities shall expedite the production of the report of the DNA test as far as possible.
the undertake to file the affidavit in service, my lord, they only because it has not yet been absorbed.
Learned counsel for the petitioner is granted leave to file the affidavit of service during the course of the day. During the course of the day.
Okay.
Thank you. Do that, please. I have not recorded undertaking, but please do that. By 100% policy? No, 100% good.
Not about the petition.
Yes.
My lord, offense under section 302. My lord, in this case, my lord, 302, my lord. In this case, my lord, husband had allegation is that husband had killed his, my lord, wife. But about 1.5 years ago, this petitioner got married with the, my lord, deceased. And after the marriage, they used to quarrel. And, my lord, there is a my lord, allegation of, my lord, mental torture inflicted by the wife to the petitioner, my lord. And
Allegation where? Where have you alleged that?
my lord, this is my instruction, my lord. My lord, that is the instruction. And my lord, on the date of incident, my lord, they quarreled each other and out due to the hot altercation, my lord, this petitioner, my lord, assaulted his wife with a sharp cutting weapon. Due to such reason, my lord, she expired, my lord. My lord, I am in custody about 308 days, charge sheet submitted. And my lord, at best, this is a case of 304, not 302, my lord.
Yes, what do you say?
My lord, charge sheet submitted in this case, your lordship, 30th January of 2023, your lordship. 30th January, my lord. The present status of the case, my lord, 23rd of August 2023, charge already framed.
Custodial trial is necessary. Otherwise, I mean, offense is heinous, definitely.
Offense is serious, my lord.
But there is a chance of 304 being there.
That's true. 30, not 304.
304, my lord.
But
304,
304.
not 304.
Not 302.
Not 302, your lordship. 304 B, not 304 B, your lordship.
304, madam.
304 B not good.
না বলছি তাহলে কি করবে পার্সিডেড তো হচ্ছে না যদিও হিনেস ক্রাইম সেসব ঠিক আছে Learned counsel for the petitioner submit, we are granting it. Learned counsel for the petitioner submits that the petitioner is already in custody for 308 days and the charge sheet has been filed. Full stop next para. It is further submitted that as an outcome of a quarrel between the petitioner and his wife, comma, the victim, comma, there was an altercation and a tussle, comma, which led to the demise of the victim. Full stop. However, comma, it is denied that the petitioner was guilty of murdering his wife under section 302 of the IPC. Full stop next para. Learned counsel for the state opposes the prayer for bail. Full stop next para. Despite the allegation against the petitioner being of a serious nature, comma, keeping in view the period of custody of the petitioner and that there is no reason to apprehend, no reason of any apprehension against the petitioner justifying custodial trial, comma, we are inclined to grant bail to the petitioner on the usual conditions. Full stop. Accordingly, CRM DB number 559 of 2023 is allowed, comma, granting bail to the petitioner on condition that the petitioner furnishes a bond of rupees 20,000 with 2 sureties of like amount each, comma, one of whom must be local, comma, to the satisfaction of the which court?
CGM Alipurdwar.
Of the learned CJM, comma, Alipurdwar, full stop. The petitioner shall not leave the territorial jurisdiction of the trial court during the entire period of trial and shall attend each and every date of trial, full stop. Further, comma, the petitioner shall not, comma, directly or indirectly, inducement, threat or promise. Thank you.
Pass ready go to the
For the petition. Lordship, this case though relates to 6 of POXO Act, but I am
Yes.
relying the magic, in this case, charge sheet has been,
State is
in this case, Lordship, charge sheet has been filed and 207 has been complied. So I got the opportunity.
we'll pass it over.
Lordship, as your lordship.
Possible.
Yes,
May
pass
fix on tomorrow, your lordship.
Very well, not today, then tomorrow. Come back tomorrow. Thank you. State. Yes.
Prefer not to do, your lordship.
Refuse. Move the matter.
But it's an NDPS matter, your lordship.
So what? Third matter, no.
Lordship, I'm not briefed about the fact. your
Well,
lordship.
not. Yes.
It's my matter.
Yes, Mr. Ganguly. No.
Lordship, this is a case under NDPS Act.
Right.
I have twofold submission before your lordships. First, I have to place my case basing upon completely medical ground. Lordship kindly sees page 23 of my petition. Lordship, this is one specimen of examination. Sample was taken from the throat of the petitioner, and Lordship sees the impression, the moderately differentiated cell carcinoma grade 3. So, Lordship, the condition of the patient grade 3, stage 3 carcinoma is suffering.
This will grant will on that ground only. The petitioner suffers from grade 3 stage of carcinoma as evident from the medical reports annexed to the petition. Full stop. Although there is a presumption under section 37 of the NDPS Act, comma, keeping in view the uh, physical and medical condition of the petitioner, comma, we are inclined to grant bail on humanitarian grounds, full stop. Accordingly, CRM NDPS 587 of 2023 is allowed, granting bail to the petitioner on condition that the petitioner furnishes a bond of rupees 10,000 with two sureties of like amount each, one of whom must be local. But rest is the same. We attend each date of trial, shall not leave the territorial jurisdiction of the trial court, or shall not make any inducement, threat, or promise. অন্যগুলো যা আছে তাই।
Deeply obliged.
Thank you. Oh, to the satisfaction of which court? NDPS court? Special court NDPS?
Lordship, this is a case of Kotwali police station. That is Jalpaiguri, Lordship, second court, Jalpaiguri. Special court,
Special court NDPS, Jalpaiguri.
Deeply obliged.
Thank you. Monday, not today, not this week.
My lords, on for the petitioner.
Yes.
My lords, if I'm permitted.
Yes, please.
This is a case registered under section 21C, 22C, and 27A of
NDPS.
27.
One day accommodation, super all.
My lord, as per my instruction, my lord, I was supposed to.
Acha, fir will
I being the advocate on record, my lord, I think it should be my call. My lord.
Not today. Not today. But he has to be there tomorrow, even if you appear.
You will be with us. Because we have joint venture.
Tomorrow he will argue, but you will be there. If he fails somewhere, you add. Come back tomorrow, yes. Yes.
I'm for the petition.
Right.
My lord, in this case, this is a renewal of prayer copy.
When rejected?
No, Lordship, this is rejected on 27th February. Now, can you see? My lord, can you see the page number 18? Another co-accused who is standing on the
State.
My lord.
Co-accused has been released.
Court has been released, relying the judgment of the Honorable Special Bench, SABYASACHI. That is the page number 80. Who's
Co-accused?
Lordship, one indulgence I am taking. Now, can you see your Lordship? The rejection order passed by the Learned Court on page number 24. Can you see? This is an elaborate order. Why my petition was rejected by the Learned Tribunal?
Yes.
To maintain the judicial discipline, the prayer was turned down by the Learned Trial Court, though it was observed by the Learned Trial Court, the both are of the person standing on a similar plea. Actually, the 27th February, when my prayer was turned down by the Honorable Coordinate Bench, that point was not raised.
No, coordinate bench order is annexed here.
Lordship.
Where is that?
That is annexed, your Lordship. I am mentioning.
Page 18 is a co-accused.
Page 18 is the co-accused.
Right.
Who got the bail on the after lapse of 3 days.
Page 21.
21.
21.
On that point.
Originated my application.
Including contemporary.
You want us to represent properly, right?
Can you see the page number 21? And the page number 18, after lapse of 3 days, when the point was raised, the co-accused got the privilege of bail.
May I, Lordship?
Lordship, may I?
Lordship, he has to show that he filed an application seeking a statutory bail.
That is mentioned in the page number 24.
No.
Can you see the order?
The entire
Can you see the
submission
order?
is recorded there, but whenever he is claiming statutory bail, he has to show that he filed an application. He availed of the right individually.
Lordship.
What is the harm if he could?
What is page 24?
My application is not paginated, Lordship. I am unable to.
Please come to the certified copy, show him that page.
Kindly.
Lordship. From perusal, the middle paragraph. From perusal of the record I find. This is the observation of the lower court, Lordship, or the
Obviously,
trial court. But whenever someone is claiming a bail, statutory bail, he has to show that he had applied before the trial court.
that.
Statutory bail application was filed.
Mr.
Wait.
No,
Mr. Bhumik, let your turn come. Let your turn come.
Okay, you will say.
He has to show that I am aggrieved by this order. I filed an application before the trial court in the interregnum period when the charge sheet was, when the 180 days expired, charge sheet, neither charge sheet nor extension is there. I filed an application and I availed of my right. If he could obtain the certified copy of this order, what precluded him from applying the certified copy and attaching the certified copy of the exact order by which he is aggrieved? And he has not mentioned this any order in the 439 application by which he is aggrieved in the cost title, Lordship.
That's a technical approach. If it's statutory bail, why can't we grant it for the first time even?
Lordship, he has to show that he applied. That order has to be there. Let him come with the order.
Where is the bar if there is no such order? Apply the principle of statutory.
Unless, Lordship, he applies for statutory bail, he cannot claim it.
Not statutory, then we'll grant ordinary bail.
In that case, I am paralyzed. I have no option.
Lordship.
Yes, why didn't you apply for statutory bail? You have not applied for it. He's right on that.
If we rely, the judgment of the Honorable Supreme Court, the Rakesh Pal
Yes, that is what I said, told him. Yes.
In any state, even after passing the judgment passed by the Honorable Special Bench, and what the observation is there as per the trial court, that the both the persons standing on the similar footing, it can be presumed the law of parity may be law of parity may be applicable.
Yes, if not statutory bail, then Article 14.
That is the discretion of my lord. I cannot encroach upon that. I don't dare.
Learned counsel for the petitioner submits. Learned counsel for the petitioner submits that the petitioner is entitled to statutory bail. First up, it is contended that the statutory period of 180 days of detention has expired, but without any report being filed. First up, next para. It is contended that one other co-accused person has already been released on bail. First up, next para. Insofar as the previous rejection of the petitioner's prayer for bail is concerned, annexed at page 21 of the present petition, it is submitted that the same subsequently the same was now at that juncture, there was no order in favor of the co-accused with regard to statutory bail. First up, it is pointed out by virtue of the annexure at page 18 of the present petition that on March 2, 2023, after refusal of bail to the petitioner, the co-accused was granted bail. First up, next parallel, counsel for the state opposes the prayer for bail and argues that unless the petitioner himself applied for statutory bail, the said advantage cannot be granted to the petitioner at this stage. First up, next para. We find from the records that although the petitioner himself might not have applied for statutory bail, the same circumstances which were available to the other co-accused are also applicable to the petitioner, entitling the petitioner for asking for statutory bail. Push up that apart, even on principles of Article 14 of the Constitution of India, there is no reason why a similar relief ought not to be extended to the petitioner, having been granted to a co-accused standing on a same footing with regard to the same offense. Pushed up, in such view of the matter, we are inclined to grant bail to the petitioner as well. Accordingly, CRM NDPS 607 of 2023 is allowed, thereby granting bail to the petitioner on condition that the petitioner furnishes a bond of ₹10,000 with 2 sureties of like amount each, one of whom must be local, to the satisfaction of the learned judge, special court under NDPS Act, additional sessions judge, second court, Jalpaiguri.
Just one interview. Nowadays, the designated court is first court.
First court, all right. Very well. তাহলে স্পেশাল কোর্ট এনডিপি আন্ডার এনডিপিএস অ্যাক্ট কাম ফর্ম গুলো কেটে দিন কাম এডিশন কমা ফার্স্ট কোর্ট এট জলপাইগুড়ি full stop the petitioner shall attend each and every date of hearing and shall not leave the territorial jurisdiction of the trial court during the entire period of trial. Full stop that apart, comma, the petitioner shall not, comma, directly or indirectly, make.
One indulgence. My strong objection may kindly be noted.
আচ্ছা, learned counsel একটা জায়গায় বলেছেন learned counsel for the state opposes the prayer, strongly opposes them. Yes. Yes. Yeah, for this. What is the matter, please?
In this case, I am praying for bail on the ground. I am praying for bail on the ground of long detention and violation of section 41B of CRPC.
What is the period of detention?
823 days as on date.
Stage of trial?
Trial has not yet been started. Charge was framed on 12th April 2022. Thereafter, 7th number of schedule was fixed for CSW1, but till now no witness were examined by the prosecution. This is the formal copy of the cause list of trial.
Yes, 823 days, Mr. Ganguly. Sufficient.
Regarding 41B, it's
Next one 41B now.
41B is usual.
No. First I am want to say regarding the detention.
Definitely, yes. Learned counsel for the petitioner argues that
charge sheet was submitted on last of December of 2021.
charges framed on April 12th, 22.
20 judges framed.
কি বললেন? Petitioner argues that the petitioner is already in custody for 823 days. Full stop. That apart, comma, the provisions of section 41B of the NDPS Act were contravened. Full stop. Next para. The charges were framed, comma, it is contended, comma, on April 12, 2022, but the trial has not seen any progress since then. Full stop. Next para. Learned counsel for the state opposes the prayer for bail and argues that the provisions of section 41B of the NDPS Act were fully complied with. Full stop. Next para. Upon hearing learned counsel, comma, it is evident that the petitioner is already in custody for 823 days, comma, despite the trial having not yet commenced effectively, comma, although the charges were framed as far back as on April 12, 2022. Full stop. In view of the above period of incarceration, comma, we consider it to be sufficiently mitigating to entitle the petitioner to bail. Full stop. Hence, CRM NDPS 608 of 2023 is allowed, granting bail to the petitioner, same as the other. 10,000 to sureties. So, to the satisfaction of the special court NDPS, Jalpaiguri? Shiliguri. Shiliguri second court.
Special court.
Yes, special court NDPS Shiliguri. NDPS এ objection গুলো strongly objected এর মধ্যে কিছু করে stated যেটা হ্যাঁ strong. Yes. POXO also strongly or only in yes. But in the others we will record weekly objected to. That is the only condition. We understand. Definitely. Yes. Password না এলে কি করে? Password mention করলে কি ওটা হতো নাহলে ওটা not today ধরে রাখো। আচ্ছা, we are thinking we will continue with the bail matters up to 3, up to recess. And after recess, should we take up anticipatory bail up to 3 and then take up our single benches? Or should we continue with the bail? Bail is more important. Very well. Then we'll continue with the bail till 3. Let us proceed with that. So up to 3 we'll be taking up bail, and after that we'll disperse in a single bail. Continue.
Lordship, 40 and 41.
Your not today prayers all are rejected. Yes, move the matter.
It's my matter, not our matter. I have been instructed from another senior lawyer.
Very well.
40 and then 41.
40, 41. Today, not today, 42. Rag. What is your name, please? Satyajit Pal. 42. Yes.
I am for the petitioner, my lords.
Yes, Mr.
There
Mishra.
are two petitioners before my lordship.
Right.
If I can have straight away, my lords, to page number 13, which happens to be the FIR. On the very first page, my lords, after the tabular format Roman 11, my lords will find that the date mentioned in the third line is 6th March 2022.
Yes.
Third line, lords. That ideally should have been, my lords, 6th March 2023. Now I take that as a typographical error, my lords. On the very next page, in the middle paragraph, 5th line from the top, my lords will see that it has been written that all the 4 apprehended persons. Middle paragraph, my lords, 5th line from the top.
Yes, all the 4.
Whereas the apprehended persons were 5. Now, my lords, in the same middle paragraph, my lords will see that the vehicle number is this, my lords, is 5th line from the bottom.
Yes.
The vehicle number is WB60J 84884. Now, my lords, no, there is no 5-digit number in a vehicle. It should be 8484. So that is another error. On the next page, my lords, at the end of the first paragraph, my lords will find there is a line that says that interrogation, they also disclose that they have been dealing with such business of selling brown sugar. Whereas, my lords, I have been
This is which paragraph? Which paragraph?
in the last line of the first paragraph, my lords.
Oh, yes, yes, brown sugar.
On interrogation, they also disclose that they have been dealing with the business of brown sugar. Whereas, my lords, what has been recovered from me is, my lords, ganja, 79.5 kgs of ganja. In the last paragraph, my lords, on the very
Your client paid how much for each of the mistakes? Mr.
my lords, this happened on the spot, my lords. And the last one is very laughable, my lords. On the very last paragraph, my lords, will see second line, the above noted arrested lady accused person. All of these are male accused persons.
No, but this person apprehending you, he should be put behind bars actually for this negligence.
There are other errors, my lord. In the next page, page 16, my lords, there is overwriting in the time. This is the Caesar list, my lord, I am referring to. My lords will see that on 6th March 2023, in between there is an overwriting in time. My information, my lords, is that the carbon copy and the one that is there in the court notes, there is a discrepancy between them. On the next page, next to next page, my lords, at page 18, my lords, again there is an error. Apart from other than that, my lords, the secret information was received at 1:15 hours. Search and seizure was done between 7:15 to 20:45 hours. But no search warrant or authorization from magistrate was obtained. No nil Caesar list has been obtained. And, my lord, the sampling out to be done within 72 hours. That was not in the instant case.
Yes. What else remains?
My lord, 75.9 kg of gaja. And these discrepancies are there. It is true. My lord. It is true.
He'll take advantage of this.
It is true. My lord.
Learned counsel, we granting Learned counsel for the petitioner points out to several discrepancies in the FIR lodged against the petitioner as well as the Caesar list. Full stop. For example, the date mentioned in the first page of the FIR is March 6, 2022, whereas the alleged incident occurred in 2023. Full stop. In the second page of the FIR, it is mentioned that there were 4 persons who were apprehended, whereas in reality there were 5 persons, as it appears from the other portions of the FIR itself. Full stop. Thirdly, in the third page, the FIR mentions regarding apprehension of brown sugar, whereas the allegation is that regarding gaja. Full stop. Next para, learned counsel also points out several other discrepancies in the Caesar list as well as the FIR, including certain instances of overwriting in the Caesar list, which palpably cast doubt on the process of apprehension of the petitioner itself, thereby mitigating the presumption raised under Section 37 NDPS Act otherwise. Full stop. Next para. In the absence of such presumption, there is no reason why the petitioner should be kept in incarceration indefinitely, full stop. Accordingly, CRM NDPS 615 of 2023 is allowed, granting bail to the petitioner on
There are
condition.
two of them, my lords,
Petitioners, comma, on condition that the petitioners furnish bonds of rupees 10,000 each, comma, with 2 sureties each, comma, one each of whom must be local, full stop. That apart, comma, the petitioners shall not usually leave the territorial jurisdiction of the trial court.
Satisfaction of special NDPS first court Jalpaiguri.
ঠিক আছে,
One indulgence, my lord. Objection, madam.
অবজেকশনটা একটা সরি একটা অবজেকশন কোনখানটা ঢুকে বলুন তো, পিটিশনের যেটা বললাম বা গোড়াতে করে দিন। At the outset, comma, learned counsel for the state vehemently opposes the prayer for bail, primarily on the ground that the allegations leveled are under the NDPS Act, raising the presumption under section 37 of the said Act.
I'm deputy.
Thank you.
Lordship on passport item number 89.
29, other side is there? Yes. 29 টা দেখো তো। Let the file be traced over. Yes, please.
Lordship, 14A, 14C, Foreigners Act, Lordship, this petitioner Indian citizen, Lordship, behind the bar for more than 4.5 months, Lordship. Co-accused confession statement, this petitioner name transfer, and page number 9, Lordship.
Co-accused?
Co-accused statement, this petitioner.
Oh, quite on those.
And Lordship, page number 9, Lordship.
Yes.
This petitioner physical handicap, Lordship.
What sort of handicap? Indicated somewhere.
Page number 9, Lordship.
9, where is it?
45%.
Achha, wait. Yes, what do you say? Accused. Huh.
And the Lord, when transit Bangladeshi people through him trespass to the Bangladesh and from India.
But on the basis of co-accused.
On page number 30, 33, 34, and 35, the 161 statement, the poet.
No, apart from co-accused statements, anything else? On the basis of the co-accused, that is his allegation. They are co-accused, so co-accused statement. Co-accused statement এর উপর ভিত্তি করে তো করা যায় না। দেখো 30 30
April 2022.
Co-accused statement এর ইস্যু তো করে হয়েছে। বলছি ইন্ডিয়ান সিটিজেন, সেটা তো বিচার হবে। ঠিক আছে, থাক, এখন বেল দিয়ে দিচ্ছি। The allegations leveled against the petitioner are under the Foreigners Act, which it is submitted by the petitioner that the petitioner was apprehended solely on the basis of statements of co-accused persons. Because of that apart, comma, the petitioner alleges to be an Indian citizen. Which of next parallel, counsel for the state opposes the prayer for bail and submits that the co-accused persons are Bangladeshi citizens. Full stop. That apart, comma, it is alleged that the petitioner is one of the kingpins in the racket of smuggling Bangladeshi citizens into India. Full stop. Next para. It transpires from the materials on record that the allegations against the petitioner are primarily on the basis of statement of co-accused persons, comma, who are Bangladeshi citizens. Full stop. Next para. It is well settled that the mere statement of co-accused persons cannot be a premise of indicting a person. Full stop. Hence, comma, we do not find any reason to further incarcerate the petitioner during the trial. Trial has begun. Charge sheet?
Charge sheet submitted, Lordship.
Charge sheet submitted.
So accordingly, CRM DB 556 of 2023 is allowed, granting bail to the petitioner on condition of the petitioner furnishing a bond of 10,000, one of whom same will be local to the satisfaction of the
Additional Sessions Judge, Mekliganj, Kuch Bihar.
additional sessions judge, Mekliganj, Kuch Bihar. Full stop. Next para. Over and above, comma, as condition of bail, comma, the petitioner shall not leave the territorial jurisdiction of the trial court and shall attend the trial as and when the same begins on each and every date, and also make himself available. No, charge sheet has been filed to him. Also make himself available. So that apart, comma, the petitioner shall not make any inducement, threat or promise.
Deeply obliged.
Thank you. আরেকটা দেখে নি তারপর yes
This is my renewal of my prayer for bail, my lord.
this is a
Renewal of my prayer for.
when rejected
Rejected in the month of February. In the month of February, my lord, petitioner has custody about near about 3 months, my lord. 3 years, my lord, sorry, my lord. After rejection, there is no progress in the trial, my lord. There is no witness was done before the court.
where is the rejection order?
Next step, P1, my lord. I'm getting the place, my lord.
Yes, we got page 8.
Yes, after that, my lord, there is no progress in the trial, my lord. I am relying two judgment, recent judgment. One is passed by the Honorable Apex Court, another by coordinate bench. And long detention, that is rebuttable presumption, section 37, my lord. This is one by the Honorable Apex Court, another by the.
But this was available to you also on the last occasion. February also this.
Coordinate bench. We are long detention. Now following. No witness was found.
No witness has been examined.
It was fixed on 21st of June 23 for evidence. And
Examination has started.
Started after rejection. There is 7 days fixed. No witness stand before the court. And can you see the order passed by the coordinate bench? 2 years, 4 months. Accused released on bail into
That was available to you at that point of time also. Judgment does not change the scenario. Judgment is an interpretation. Judgment is not retrospective. You were 3 years in prison also then.
After rejection,
There is no hard and fast rule that 2 years, 2 months has to be the cutoff. It is on the discretion of the court. These 3 years, you are already behind bars 3 years when your bail was rejected by the same bench, same judge. Rohit Prakash is there. Rohit Prakash is there, yes.
Judgment of 5 years, madam. Supreme Court Legal Aid Committee. If any person is custody for 5 years, he must be released on bail at that time. This judgment was passed on April. Thereafter, Justice Bakshi, coordinate bench, passed order recently 2 years 2 months. This judgment was followed. Can you see?
After this, how many dates passed by in the trial after this last rejection?
35.
How many approximately?
Total 5 days, madam.
5 dates.
Yes, madam.
Ground. Learned counsel for the petitioner cites the judgment of Robi Prakash. Learned counsel for the petitioner cites the judgment of Robi Prakash versus the state of Odisha, reported at 2023 live law within bracket SC bracket close 533 for the proposition that in case of prolonged incarceration, comma, conditional liberty will override the statutory embargo under section 37 of the NDPS Act, full stop. Learned counsel also cites a coordinate bench judgment of this court dated August 2, 2023, passed in CRM NDPS 1346 of 2023 on the same proposition. Full stop. It is argued that the petitioner's application for bail was last rejected on February 27, 2023. Full stop. Thereafter, about 5 dates have elapsed, comma, without the trial proceeding substantially. Full stop, next para. We find from the cited judgments that the proposition is well settled that prolonged incarceration dilutes the presumption under section 37 of the NDPS Act, full stop. Although the said proposition was available to the petitioner at the time of last rejection on February 27, 2023, subsequently the trial was taken up on 5 dates but has not yet progressed substantially, which furnishes a mitigating factor in favor of the petitioner, for this court to lean in favor of the proposition laid down in Ravi Prakash Supra. In such view of the matter, CRM NDPS 617 of 2023 is allowed, granting bail to the petitioner, usual conditions, to the satisfaction of which court? Special Judge NDPS Siliguri, 10,000 যা যা আছে বাকিটা সব।
As usual, our objection.
হ্যাঁ, ওটা গোড়া দিতে learned counsel for the state strongly opposes the prayer for bail. Thank you. So we'll continue with bail after recess up to 3.
And kindly first 10 matters, within first 10 matters.
We will like to order record করেন learned counsel for the state seeks some adjournment to assist the court properly. So accordingly, let the matter stand adjourned till September 18, 2023, when it will be placed fairly at the top of the list. Auditor প্রথম 10টার মধ্যে দিয়ে দিও within first 10, as you said.
Yes, sir, I'm ready. I'm for the state in that matter.
Pass over, would you like me? Let us take up the matter. Pass over. Right. Pass over to one. Yes. Yes, Mr. Bhumi.
March 2023, that is 18090.
Hmm.
The case relates to 21C of NDPS Act.
Hmm.
So for the allegation is concerned, myself had a tea stall, footpath tea stall,
Right.
and some drugs, I mean, medicines and injections and some cough syrup were allegedly recovered from my stall. Now, after interrogation, I disclosed before the concerned police officer that one owner of a chemist shop gave to him. On the strength of that, that owner was also arrested and both are forwarded on the same date for the jurisdiction.
Right.
Subsequently, the mastermind, if I assume the story, got the privilege of building.
Oh.
Sumit Das. In the forwarding report of the empire, that Sumit Das, from the chemist shop of Sumit Das, those articles were procured by Mr. Now, actually, and that is your allegation in the empire. So Sumit Das is the mastermind, as he is influential, he got the privilege of bail, stating it earlier that the name transferred from the mouth of myself.
Yes, he is entitled because his name was yes, he was a co-accused, that's why. So he has a better ground of bail for Daniel.
Because actually there is no tea stall of me. There is not if there,
What are you doing in this tea stall? Oh, acha.
I have no tea stall. If a cheater in this case, charges have been filed. If in the course of investigation, if iota documents to show that I had a tea stall at a particular LSPO.
Acha, 21C, this 37 is not applicable.
Yes, applicable. 21C is commercial content.
Some extent applicable.
Not to some extent, totally applicable.
Now, Lordship, my humble submission to your Lordship.
To some extent.
I have already said that to some extent applicable.
No, that was just being gentle to the court because I said it's not applicable. I was wrong. He tried to defend me. Yes.
The allegation is that I have no tea stall.
How do you overcome 37? I mean, in your case.
Now, so for the serial list itself, that has been mentioned in the serial list, in a LRP mode, that is unpopulated. Some cartoons were recovered at a more populated area. I was standing there, I have been.
You say don't have a stall at all.
No, if there is the slightest documents to show that this petitioner had any tea stall or anything else at that area, I have no.
So let us hear this state, then yes.
Lordship, this is not the case actually. The allegation is that recovery was made from his medicine store.
No, I have no medicine.
Wait, Mr. Bhumi, wait.
Yes.
The seizure list shows that from the possession and shop of Deepak Shah. The seizure list, here's his signature, Lordship. The seizure will not go. The seizure, there is a seizure of 940 tramadol capsule, 250 gram is the commercial quantity, Lordship, and yes, admittedly, the documents relating to the shop where from the seizure has been effected is in the name of one Shomit Das. This is the case of the person.
How is he involved? I mean,
the recovery has been made from him.
Which has got the bill.
The shop is of Shomit Das.
Of the ownership, the documents of registration, drug license, everything those are in the name of Shomit Das.
So what is his involvement
His
then?
involvement that he runs the shop, but I don't have any document to show his ownership. This is true.
He was there at the time of
The huge quantity of recovery will not go. The recovery is there. Seizure list BHATTACHARYYA.
recovery from the shop of one
From the
Shamir.
shop of- No, from the shop of Deepak Shah.
But you say it's in the name of somebody else.
Yes, yes. The document show.
Who got a bail?
Document shows that it is in the name of Shomir Das. The enrollment certificate, the drug license is in the name of Shomir Das.
Shamir Das যদি বেল পেয়ে থাকতেন দীপকের নামে তো কিছুই নেই।
Rishita Medical Hall, proprietor Shomir Das.
It was recovered from his exclusive possession.
From the
No,
shop, but
এটাও না।
his position
From
is
his
there
shop
because,
বলতে তো shop owner
because
নেই।
seizure list shows his signature.
He was there.
He was there.
Welcome. Learned counsel for the petitioner contends that one Shomir Das, comma, in whose name the shop, comma, where the recovery was made, comma, has been enlarged on bail, full stop. The petitioner is on a lesser footing and as such ought to be granted bail as well. Full stop. Next para. Learned counsel for the state seriously opposes the prayer for bail and submits that commercial quantity was recovered from the petitioner's shop. Full stop. Next para. However, comma, on query of court, comma, learned counsel submits fairly that subsequently it was seen that the papers relating to the shop is in the name of one Shomir, comma, who has been enlarged on bail. Full stop. Next para.
The paper relating shop, Lordship.
Pardon?
The drug license and other trade license.
So next para, it is clarified that drug license and other licenses regarding the shop were in the name of Shomir, comma, whereas the petitioner is actually in charge of running the shop. Which of next para, a perusal of the materials indicates that all the licenses pertaining to the shop where the recovery was made stands in the name of a different person, comma, who has been enlarged on bail. Full stop. Merely on the premise that the petitioner's signature finds place in the seizure list, comma, does not create a presumption under section 37 of the NDPS Act against the petitioner. Full stop. Hence, comma, on the same ground as the said Shomir, comma, the petitioner is also entitled to bail. Accordingly, CRM NDPS 622 of 2023 is allowed, granting bail to the petitioner on condition that the petitioner usual 10,000 to sureties to the satisfaction of
Special code NDPS Act Jalpaiguri.
special code NDPS Jalpaiguri. বাকি সব সেম হ্যাঁ ইয়েস ওই ট্রায়াল অ্যাটেন্ড করবে Yes.
I'm paying for 1 day's accommodation. You want to-
Not today.
Around 47, I'm for the petition.
Yes, please.
My lord, the alleged seizure is 150 bottles of Hon'ble cough syrup.
Hmm.
Now, my lord, I am in custody since 21st of December 21.
Hmm.
As on date it is 630 days. Now, my lord, not a single witness has been examined. Now, my lord, I'll kindly, on the merits, my lord, I'll kindly take your lordship to the seizure list. It is at page 12, my lord. My lord, will see the description of the seized articles at page 12.
Your bail was refused previously?
My lord, in the year 2022.
What has happened in the meantime? No progress in the trial.
No progress in the trial. No.
Seizure list. What about your seizure list?
Yes, my lord. Kindly see the description of the seized articles. My lord, it says 150 bottles of Hon'ble cough syrup, such and such compound.
Yes.
Each bottle contains 100 ml, which contains codeine phosphate 10 mg each. There are no other descriptions, my lord. No date of expiry, no manufacturing date, no descriptions of the seized articles. I fail to understand how will this matter go to trial, my lord. It is a specific mandate under the NDPS Act, to describe the seized articles in their particularity. My lord, this exact argument was, my lord, considered by a coordinate bench, not led by Justice Moushumi Bhattacharya. But I had placed these same arguments and the petitioner was granted bail, my lord. My lord, in this case, there is a prolonged period of custody.
That's a different matter. I mean,
That's a different matter.
but the same logic.
Yes, my lord. So, my lord, there is prolonged period of custody. The
Yes, what do you say?
My lord,
Period of custody and this other
Yes.
thing.
period of custody is, my lord,
That is the most fatal thing against you. I mean, in favor of bail.
my lord, charge sheet submitted, my lord, 24th of September 2022. 24th of September 2022, along with CFSL group.
charges were framed on 3rd of November 22.
Charge framed and my lord, next date fixed for evidence, that is on 17th of November 2023.
Not a single witness examined till
Not a
now.
single witness till date examined.
Learned counsel for the petitioner contends that the petitioner is in custody for about 630 days. First up, it is further argued that there are certain serious defects in the seizure list insofar as the specific details of the allegedly seized articles are not disclosed. First up, learned counsel places reliance on an unreported judgment of a coordinate bench on such premise, comma, indicating that in the absence of disclosure of the relevant details, comma, no case of presumption under section 37 is made out. First up, next para. Learned counsel for the state seriously opposes the prayer for bail and contends that the charges have been framed and the charge sheet has already been submitted. First up, it is argued that the petitioner ought not to be granted bail. First up, keeping in view the prolonged period of custody, comma, which is itself a sufficient mitigator of the presumption under section 37 of the NDPS Act, comma, and keeping in view the arguable case made out by the petitioner regarding sufficiency of the seizure list, comma, we are inclined to grant bail, full stop. Accordingly, CRM NDPS 629 of 2023 is allowed, granting bail to the petitioner on condition that the petitioner furnishes a bond of rupees 10,000 with 2 sureties of like amount each to the satisfaction of the special learned judge, special court, NDPS at Siliguri, second court at Siliguri, second court at Siliguri. Push up, other conditions are same.
Kindly ensure the attendance during trial.
Attendance during trial shall not leave territorial jurisdiction of trial court and shall not make any inducement threat promise. Those are by default there in the order.
But I do not 48 and 49 are praying for only not today.
My lord, kindly 48 day after tomorrow, that my lord, case diary is not available.
48.
48.
48 thale not day after tomorrow ota not today or 49 hoche only not today. Day after tomorrow means not today and only not today is only not today. Yes. Yes.
I'm for the petitioner.
Yes.
I'm for the student.
What were you doing there running after?
No, I was calling my friend.
Yes. What is the matter about?
This is a case. Another section. Another NDPS Act, Lordship, alleged recovery of heroin. 2 persons were apprehended. One was found in possession of commercial quantity of heroin. And I was found in possession of 30 grams of heroin, which is below commercial quantity. 37 is not applicable to me. I am in custody for 1 year, 9 months, 5 days. Seizure list is clearly there is a distinction has been drawn in the seizure list. Distinction has been drawn in the seizure list clearly that my exclusive possession was just 30 grams, which is below commercial quantity. Now, my second point is, Lordship, in this case, there is a gross violation of mandatory provision of section 52A. How? Lordship, in this case, the samples drawn from the spot were sent to FSL on 14/12/2021. And Lordship, the inventory certification was done on 18/12/2021. So before the inventory certification was done, it was sent to FSL. It's a gross violation of the mandatory provision. And because this document is to be, the alamats will not be produced now. These documents will be produced as evidence of the contraband.
Yes, what do you say? On both counts. He has got a very good case on both counts.
This is the Caesar list.
Hmm.
Roman 3, my lord.
Roman 3.
Roman 3. This 30, exclusive position is 30 gram.
30.
Yes, my lord.
So he's right.
Yes, my lord. And from another accused, 270 grams.
He's behind the bars.
He's behind the bar.
Learned counsel for the petitioner argues that the petitioner is behind the bar for 1 year, 9 months, 5 days. Puts up that apart, comma, there is gross contravention of section 52 capital A of the NDPS Act insofar as the samples were sent for FSL report on December 14, 2021, whereas the inventorization was done only on December 18, 2021. Footstep, next para. Further, comma, it is argued that even as per the FIR, comma, the quantity of the contraband material seized from the person of the petitioner was below the commercial quantity. Footstep, next para. Learned counsel for the state opposes the prayer for bail. Footstep. However, comma, keeping in view the above mitigating circumstances made out by the petitioner, comma, we are inclined to grant bail. Footstep, accordingly, CRM NDPS 633 of 2023 is allowed, thereby granting bail. Usual. Through the satisfaction of which court? Special court NDPS, Siliguri. Siliguri. Rest remain the same, 10,000 to COTs and all. Attend each date of trial and not
Leave the jurisdiction.
not to leave jurisdiction, attend each date of trial and not make out English.
Lordship, only not today, Lordship.
Lordship,
Just only-
last.
You are always ready in matters.
Taken twice, Lordship. Last circuit, Lordship. Taken twice.
Lordships, what happened, your lordships? The earlier occasions, could direct me.
Kalke top पे दे दियो.
Kalke.
Tomorrow at the top.
Yes.
So that they cannot avoid further as per your allegation. Yes. Next. $52 হলো না? 52 not today. Yes,
Not 53, I'm for the petition.
right.
Lord, 223 is 23 days of custody as on the date of filing. My lord. My lord, I'll straight away take your lordships to the FIR. Is that, my lord, page 11?
Hmm.
6 bottles of cough syrup.
My lord, from my possession, the FIR.
6 bottles.
6 bottles.
What are you doing with those?
My lord,
6 bottles, I mean.
the FIR itself specifies that 6 bottles of cough syrup were recovered from my exclusive possession. My lord,
What is this? You should advise your client. You are in custody for 223 days, 5 days.
3 days.
Apply for quashing the FIR against you.
I would certainly.
Learned counsel for the petitioner contends that allegedly 6 bottles of Onirex ONE-REEX cough syrup was recovered from the petitioner, comma, which is not contraband article above commercial quantity at all. Full stop. Moreover, the petitioner is already in custody for 223 days till the date of filing of this application. Full stop. Next parallel, and counsel for the state opposes the prayer for bail. Full stop. However, comma, keeping in view that the petitioner is already in custody for quite some time and the presumption under section 37 of the NDPS Act is not applicable to the petitioner, comma, we are inclined to grant bail. Full stop. Accordingly, CRM NDPS 640 of 2023 is allowed, thereby granting bail to the petitioner. Other things same. to the satisfaction of Special Judge NDPS at Second Court at Siliguri. Thank you. আসলে ডিসপোজাল করতে ওইগুলো ডিসপোজাল করতে পারে অনেক ছিল হ্যাঁ বাকিগুলো সরিয়ে দিয়েছে ওটা হ্যাঁ এটা পারেন yes
My lord, I'm for the petitioner.
right
My lord, this case is registered.
Mr. Karmik is not there in this matter.
Not.
Yes, he's sitting there behind watching you. Yes, what is it?
No,
Right. Yes, what happened? No, no, it's all right.
My lord, this case is registered under section 21C and 22C of NDPS Act. My lord, I'm behind custody since 30th of December 2021. 621 days of custody, my lords. My lords, I'm praying for bail on two main grounds. My lords, kindly see the Caesar list of this case. My lord, the arrest memo of this case, that is on page number 15 of my application. My lord, the column 10 of the arrest memo.
Yes.
It's signed by one Ganesh Mohanto.
Part of the team.
Now, my lord, he is not even not the part of the team. Nowhere it is mentioned his name, and not even he is charge sheeted as a witness. My lord, kindly see the charge sheet that is in page number. Page number 17 of my application, my lord. In the charge sheet itself, his name does not transfer. And moreover, my lord, since more than 2 years I'm behind the bars, not even a single witness till today has been examined. And my lords, the other ground being, if I'm permitted, my lord, the other ground being the petitioner, when he was arrested, he was of 22 years of age. And my lords, till today, no witness has been examined. If I'm permitted by your lordship to rely on only one judgment by the apex court. My lord, in this case, my lords, one reformative approach was taken by the
Justice Ravindra Bhatt, yes, yeah, right.
My lord, here in this case, the petitioner was of 23 years of age. And in my application, my lord, the petitioner is of 22. My lord,
75 bottles of cough syrup, codeine mixture, lordship, above commercial quantity, much above commercial. 10 bottles is commercial quantity, lordship.
11. What about the stage of trial?
Lordship.
What about Ganesh Mahato? Mohanto. He's not there in any, I mean, in any of the places.
Lordship, give
Yes, take your time, take your time.
One has been examined, lordship, trial has commenced.
It's 621 days, you said.
my lords.
So we'll consider that in grant. Learned counsel for, we are granting. Learned counsel for the petitioner seeks.
About 41B, lordship, I have a submission that may kindly be recorded.
41B, he is not taking
he's not taking
precisely. Yeah. At least at this stage, he is not taking. Learned counsel for the petitioner seeks bail on several aspects of the matter. First, it is submitted that the petitioner is already in custody for 621 days and the trial has barely begun. Next para. Moreover, one Ganesh Mahato / Mohanto found place in the signature column under clause 10 of the memo of arrest, but was never mentioned anywhere else, including the charge sheet. It is further submitted that the petitioner was 22 years old at the relevant point of time, and learned counsel places reliance on a judgment of the Supreme Court in Muhammad Muslim alias Hussain versus State within bracket NCT of Delhi bracket closed, where the Supreme Court adopted a reformative approach. In the said case, the appellant was around 23 years of age. Next para, learned counsel for the state opposes the prayer for bail and submits that above commercial quantity of material was found on with the petitioner. That apart, it is submitted that trial has commenced in the matter. Next para, keeping in view the period of incarceration of the petitioner, read in the context of the reformative view taken in Muhammad Muslim alias Hussain Supra by the Supreme Court, as well as a cloud having been cast on the signature of one Ganesh Mohato alias Mohanto in the memo of arrest, comma, we are inclined to grant bail to the petitioner. Full stop. Accordingly, CRM NDPS 641 of 2023 is allowed, thereby granting bail to the petitioner on condition that the petitioner furnishes bail such and bond such and such 10,000 to the satisfaction of Special Judge NDPS Court at Siliguri. You will not leave the territorial jurisdiction, attend each day of trial, and
One local surety may be given.
yes, two sureties, one of whom must be local.
And my elephantine objection, Lordship.
I'm grateful, my lord.
Without recording elephantine.
Lordship.
Objection কে কি দিয়েছে অবজেক্টস বলেছি তো সিরিয়াসলি বলেছি নাকি হ্যাঁ বলেছি মনে আছে সিরিয়াসলি করে yes
Lordships, I am for the petition.
right
I am for the state, your lordship.
Yes,
In this case, your Lordships, from the house of one Rubiul Islam, 13 cartons of cough syrups was recovered.
please take the microphone. 13 cartons, yes.
13 cartons of cough syrup were
Right,
recovered from
right.
the house of the Rubiul Islam. Lordships is to be considered that from the FIR, the investigating of the FIR maker stated that one vehicle was coming with huge quantities of cough syrups delivered to the house of two persons. And subsequently, not from the vehicles, any such contrabands were recovered. This petitioner is the driver of that said offending vehicle.
No, vehicle was coming to that place.
The vehicle was parked near the house of this Rubiul Islam.
Yes.
But the complainant state that these contrabands were recovered from the vehicles. But the seizure list, it appears that this contrabands was recovered from the house of the Rubiul Islam. And Rubiul Islam, it is stated by that
You are the driver of that vehicle.
he is driver of the vehicle. It is handed over to the Rubiul Islam and the Liton Hawk.
So you rely on the seizure list for the present purpose.
Yes. Liton Hawk was granted bail by this learned court.
Liton
By
Hawk,
the
who was he?
Liton Hawk, where that man the delivered of that goods. As per the FIR, is enumerated. Apart from this, your lordships, that the ownerships of the said house, whether that house belongs to the Rubiul or the Liton Hawk, that not being ascertained, and the charge sheet in the meantime has been filed.
You are the driver of a vehicle. The vehicle belongs to whom?
Belongs to some transporter. Otherwise.
Grateful, yes.
And seizure list, from the seizure list part 2 is, it appears that it was recovered from the house of the Rubiul Islam and from the possession of these petitioners. How?
From the possession of?
From this petition. And this is the discrepancies, how?
You are not sitting in a vehicle. You might have been there. It might have been recovered from you.
That has not been mentioned by the FIR maker itself stated that it was recovered from the vehicle.
All right, very
So
well.
this is the discrepancy in the seizure list, your lordships. And Rubiul, the Liton Hawk has already been granted bail, and another is also granted bail. 2 orders I have quoted here.
Yes, for this.
My lord, kindly have a look at the seizure list, my lord, at page 7. 187 kgs of codeine mixture cough syrup was recovered from the house of Rubiul. It's fact. But those article was carried by this Rajesh on his vehicle.
Your FIR says it was seized in the house of Rubiul.
Yes, it's fact.
Then, so we'll grant bail. Yes.
My lord.
Commercial quantity undoubtedly.
My lord, if your lordship kindly consider the page 123 seizure list, it reveals from the RC book that the vehicle owner of the vehicle was one Gopal Roy.
Achha. He has been arrested.
No, charge sheet has been filed.
Learned counsel for the petitioner contends that there are several discrepancies in the process of arrest and complaint. First up, next para, it is contended that the petitioner was the driver of a vehicle which was parked near the alleged site of offense. First up, as per the FIR, the
Presume that he unloaded the contraband article and at that time it was spotted. It presumed.
we'll say that in our order. However, the FIR? As per the FIR, however, the articles were seized from the house of Rubiul, thank you. Of one Rubiul.
He was spread away. The time of
First up, next para. It is argued that since the complainants alleged that the articles were were recovered from the vehicle, comma, which differs with the version of the FIR, comma, no case has been made out against the petitioner insofar as the contravention of the NDPS Act is concerned. Full stop. Next para, learned counsel for the state opposes the prayer for bail vehemently and submits that there is sufficient scope of presumption that the articles in question were unloaded from the vehicle driven by the petitioner. Full stop. Next para. Considering the arguments of the parties, comma, we are conscious of the fact that the petitioner could not have any direct role to play as per the version of the FIR, comma, since the petitioner was the driver of the vehicle, but the articles were recovered from the house of one Robiul. Full stop. There is palpable discrepancy against the initial version of the complaint and the FIR on such score. Full stop. That apart, comma, two other co-accused persons are already enlarged on bail. Full stop. Hence, comma, we do not find any reason to further keep the petitioner in incarceration. Full stop. Very well. Accordingly, CRM, NDP, acha, arekta line add koro. Charge sheet has already been, since charge sheet has already been submitted, comma, there is no apprehension on such count as well. Full stop. In the light of the above observations, CRM NDPS 642 of 2023 is allowed, thereby granting bail to the petitioner. Usual.
I'm grateful to your lordship.
Thank you very much. Satisfaction of which court? Just tell him, please. This is NDPS. Special Judge NDPS Jalpaiguri.
First court, additional first court.
Additional Special Judge NDPS Additional First Court Jalpaiguri. Thank you. Thank you. Next.
I'm waiting for the question.
Right.
My lord, petitioner before your lordship has in custody for 112 days. And your lordship, the contraband articles have been seized from her grocery shop. She is the mother of a minor child and looking after a old aged father-in-law.
You run the shop?
My lords, my husband is no more. He expired in 2021.
Minor child is of what age?
7 years. My lords, on the similar circumstances, if your lordship kindly sees the Caesar list, in the Caesar list, there are two independent witnesses, those who have signed the Caesar list. But the memo of arrest has been signed by the one lady civic volunteer, column 10. This is the discrepancy in the instant case, and she is the member of the raiding party. On the similar circumstances, there are
several
mallets, but it is on the same footing as because the charge sheet has not been submitted. Investigation is still going on. On the similar logic, the coordinate bench of this honorable court has passed the order in favor of the petitioner. Let's kindly see.
Yes, in favor of?
In favor of the petitioner. There also the
yes. What do you say?
Actually, in this case, your lordships, column number 10 not filled up by the any lady.
Learned counsel has
signed by Anima Bhakta.
That's it.
Who is Anima Bhakta?
Well, kindly comes to the FIR.
This is Caesar list.
A memo of arrest, your lordships.
Kindly comes to the
Nothing
FIR.
Anima Bhakta is a member of the
raiding party.
That is not mentioned, your lordships.
Here it won't be mentioned.
Lordships in general.
What is your stand on that? I mean, what is your argument on that?
Lordships.
Do you say she's a part of the raiding party?
Lordship, it will be not.
Anima Bhakta. She is the.
At order record. Learned counsel for the petitioner has made out several mitigating circumstances for grant of bail. First, comma, the petitioner has raised a cloud on the memo of arrest, comma, since column 10 was signed by a lady who allegedly was a part of the raiding party, comma, although not admitted by learned counsel for the state. Next para. The state opposes the prayer on the ground of huge commercial quantity of articles having been recovered. However, comma, in the present case, comma, the petitioner is the owner of a grocery shop and is a widow lady having a 7-year-old minor child to look after. Full stop. Moreover, the petitioner is already in custody for 112 days. Not 112 days.
As on date. As on date. 112 days.
What are you saying? Full stop. Next
That's
para.
different.
Learned counsel for the petitioner also cites a coordinate bench judgment of this court in CRM NDPS 569 of 2023, where in similar circumstances, the petitioner was granted bail. Full stop. Next para. Although in the reported in the cited case, the legal provision of section 41 capital B of the Criminal Procedure Code, it was recorded, was violated, in the present case, there is some dispute raised by the state on such count. Full stop. However, there is nothing on record to indicate whether the lady in question, who signed, please, who signed column 10, was or was not a party, was a member of the raiding party. Full stop. Next para. That apart, there are other mitigating circumstances as indicated above, particularly since the petitioner is a lone lady having to look after her minor child. Full stop. Taking into consideration all the above aspects, we are inclined to grant bail. Accordingly, CRM NDPS 647 of 2023 is allowed, thereby granting bail to the petitioner. Other conditions are same. Please don't disturb when the court is passing the order. Yes.
Do not take.
Which satisfaction of which court?
My lords, that's written. It's Jalpaiguri. Alipurduar.
Alipurduar.
Jalpaiguri.
Special Judge NDPS.
Jalpaiguri. Jalpaiguri.
একটু দাও দেখি
Jalpaiguri.
Special Judge NDPS First Court Jalpaiguri to the satisfaction. Thank you. Next.
But I am for the petitioner. But allegation under section 21C of the NDPS Act. But allegation is that acting on a source information, police apprehended 2 persons, but and from 2 persons 500 grams of brown sugar has been recovered. And one of the person granted bail by this Honorable High Court on 6th of September and claiming the parity on the violation of 52A, my lord. Kindly see the order. My lord, I am standing on the same footing, my lord.
(52) violation, yes.
As per the notification of 2022, my lord, that
yes,
it has to be sent after certification of correctness.
So that is violated in.
Here it was sent on 21st of January 22. No. And the certification was done on 16th of February. So there is a, however, we have a strong objection because commercial quantity 500 grams.
Right.
Joint possession.
At the outset, learned counsel for the state opposes the prayer for bail on the ground that the presumption under section 37 of the NDPS Act is available since much above the commercial quantity of the contraband article was recovered. First of next para, learned counsel for the petitioner places reliance on the contravention of section 52 capital A of the NDPS Act, since the samples were sent for FSL report without proper inventorization having taken place. Full stop next para. Further, a co-accused was released on bail by a coordinate bench on September 6, 2023, on similar grounds. Full stop. The petitioner, thus, claims parity on such ground. Full stop next para. Upon consideration of the circumstances of the case, more so on the ground of parity with the co-accused who has been enlarged on bail and the cloud which has been raised of contravention of section 52 capital A of the NDPS Act, we are inclined to grant bail. Accordingly, CRM NDPS 648 of 2023 is allowed, thereby granting bail to the petitioner. Other conditions remain the same to the satisfaction of the learned judge, Special Court, NDPS Act, Siliguri. Thank you.
In item number 58, I'm on behalf of the petitioner, my lord.
Yes. Here for the state?
Hence,
It's all right. Yes.
the present petitioner is in custody for more than 5 years. The co-accused of this instant case is on bail, my lord.
Similar footing?
Similar. The coordinate bench.
Coordinating bench is there, yes. August 16th. 16th August order.
My lord, my lord. And earlier, my lord, as because he's a citizen of Nepal, my lord, earlier the previous bench had directed me to submit an Aadhaar card, my lord, so that in that within the jurisdiction of that court he can stay, my lord. And I've given a copy of the Aadhaar card to them, my lord.
Yes, what do you say?
But in a similar case, my lord, in another case, one citizen of Nepal, one bench order is there, my lord. And the
Yes.
case is evidence is in full swing, my lord. Out of 7 witnesses, 3 witnesses has been already examined.
Hmm.
And in this case, if he has been enlarged on bail, there are possibilities of absconding.
How do you get over the coordinate bench judgment co-accused?
My lord, from the co-accused, nothing has been seized. All the seizure has been made from this accused. 3.2 kg of choros.
Then may I go into the merit of the case?
But here in this particular case, the regarding the co-accused, the parameters were different. It was that under trials cannot be forced to remain in custody in the light of Article 21 and all.
Yes.
Co-accused was
Because of delayed
Pillion
trial.
driver of the vehicle. He
And
was
this
only-
person?
This person is the citizen of Nepal. He was carrying the contract. From his custody, the contraband was recovered.
My lord, 41B not complied in the case. 52A not complied. 52A was done after 1.5 years.
Yes, what about those?
My lord, actually, in NCB cases, they do not arrest from the spot. And they at first they serve the notice under section 67, and after that they detain the accused,
Yes.
and they try to call the family member of the accused. And in that case, they did not communicate. They could not communicate with any one of the family member because he is a citizen of Nepal, and
Above
they have communicated with the ministry for necessary. And
If you go back to Nepal, what is the assurance that you'll come back?
My lord, if a direction is given that he will stay within the local jurisdiction of this trial court, because in a very similar case, my lord, the coordinate bench had.
Why shouldn't your passport be deposited?
No, there is no question of passport, my lord. He is a Nepal citizen. Passports are not required.
Oh, Nepal, right.
Nepal, my lord. My lord, in a similar circumstance.
Very well, yes.
Nepal.
Yes, you'll direct grant bail.
on direction
My lord,
What direction?
for speedy disposal of and
We'll give that as well as grant bail. So both of your prayers are allowed.
my lord.
Learned counsel for the petitioner contends that the petitioner is a citizen is a resident of Nepal. Full stop. It is further argued that applying the principle on which a co-accused person was released on bail, comma, the present petitioner ought also to be released on bail. Full stop. That apart, comma. What is the stage of trial?
comments, trial has been commenced, 3 witness has been examined.
That apart, comma, the trial is still going on and the charge sheet has already been filed. Full stop. Next para. Learned counsel for the NCB places reliance on a judgment also of a coordinate bench to argue that bail was not granted in such case where the petitioner was a citizen of Nepal. Full stop. The trial, comma, however, comma, was expedited in the said case. Full stop. It is submitted that a similar order may be passed in the present case as well. Full stop. Next para. We find from the coordinate bench judgment where a co-accused person was released on bail, comma, that the court invoked the provisions of Article 21 of the Constitution of India, comma, observing that a coordinate bench, comma, in CRM NDPS 525 of 2023 had taken into consideration that under trials cannot be forced to remain in custody in light of Article 21 of the Constitution if there is no possibility of completion of trial in the near future. Full stop. Next para. We have to keep on balance the apprehension of the NCB that the petitioner may flee justice in the event bail is granted, and the fact that the petitioner is entitled to liberty, personal liberty, comma, subject to the riders of law. What is the period of incarceration? 5 years, comma, as well as the fact that the petitioner is already in custody for more than 5 years, comma, we are inclined to lean in favor of granting bail to the petitioner. Push up next para. In any event, comma, the judgment cited by the NCB does not hold any contrary proposition to that argued by the petitioner, inasmuch as the coordinate bench only observed that trial had already commenced and the petitioner was a foreign national, and as such the trial court was to conclude the trial within 6 months from the said date. Full stop. Next para. However, comma, in the present case, comma, the petitioner is already in incarceration for more than 5 years, comma, which was not a consideration before the coordinate bench judgment cited by the NCB. Full stop. Next para. Although the NCB might have a point in that the petitioner and the co-accused who has been released on bail might be on different footings insofar as the allegations are concerned, comma, in view of the long period of incarceration, comma, we are granting bail to the petitioner. Accordingly, CRM NDPS 649 of 2023 is allowed, thereby granting bail to the petitioner on condition that the petitioner shall not, usual conditions, 10,000 2 sureties, 1 local. You shall not leave the territorial jurisdiction, attend each date of trial, and to the satisfaction of Special Judge NDPS Siliguri. Thank you. Next. Yes.
I have state my lord.
What about this?
In this case, the present petitioner is in custody for 1 year, 8 months.
Hmm.
The petitioner number 1 at the time of the offense
Hmm.
is 19 years old, my lord. And petitioner number 2 is a woman, my lord.
Hmm.
Now I press on 2 points, my lord. Non-compliance of section 52A and section 50 of the NDPS Act.
50.
50.
What is 50?
The option was not given, my lord,
Oh, that's that.
to be searched before the magistrate.
Hmm.
Or yes, what? So, my lord. I'm submitting 2 documents.
Hmm.
To show the non-compliance of 52A. Now, this is a CFSL report, my lord. It shows the sample was sent on CMR number 342/21 dated 4/10/2021. It was sent, my lord, and was received on 5/10/2021. Whereas the inventory, my lord, the certification of inventory before the magistrate was done on 7/10/2021. Next page, my lord. I fixed 7/10/2021 for holding the process of certification of inventory.
52A.
Number 1, my lord. Number
Yes.
2, my lord, with regard to section 50, my lord, I have filed a supplementary affidavit, my lord. 52A2. the sample has to be drawn before the magistrate. And I also have judgment to that score, my lord. যদি দিতে হয়।
Anyway, we will grant it.
আর একটা আছে 50
50.
50.
Learned counsel for the petitioner argues that the petitioner is entitled to bail on several aspects. For the first comma, section 52 capital A of the NDPS Act have not been complied with insofar as the samples of the articles were sent on October 4, 2021 and received on October 5, 2021 for FSL report, whereas the certification was done only on October 7, 2021. Push up that apart, comma, the provisions of section 50 of the NDPS Act, comma, were allegedly not complied with as well. Push up. Next para. In any event, comma, in view of contravention of section 52 capital A, comma, the presumption under section 37 of the NDPS Act is diluted sufficiently. Full stop that apart, comma, the petitioners are already in custody for more than 1 year. And the petitioner number 1 was 19-year-old at the time of apprehension. And the petitioner number 2 is a lady. Full stop. Keeping such factors in consideration, comma, the petitioners are entitled to bail. Accordingly, CRM NDPS 650 of 2023 is allowed, thereby granting bail to the petitioner on condition that the petitioner furnishes a bond of rupees 10,000 with 2 sureties of like amount each, one of whom must be local, to the satisfaction of the learned judge, special court, NDPS Act, comma, second court at Shiliguri, full stop. আর বাকিগুলো হচ্ছে একই ওই
1 minute.
objection. প্রথমেই একটা করে দিন, learned counsel for the state vehemently opposes the prayer for bail. ব্যাস, ওটা প্রথম লাইন, তারপর বাকিগুলো, আর শেষটা তো যেটা অন্যগুলো হচ্ছে তাই ছেড়ে যাবে না ট্রায়াল কোর্টের জুরিসডিকশন। থ্যাংক ইউ। ইয়েস, না না 60, yes.
Lordship, I am for the petition. I will take instruction the present status as because they have filed the bail application regarding the.
Not today. Come back to, yes.
Tomorrow.
Tomorrow, yes. Yes.
NDPS, Your Honor.
NDPS.
My lord.
Actually, the case is a 379 case. That is FIR I have annexed. Page number 14, my lord. A detailed list has been given. This is the primary. Again, on the same thing, page number 19. They have been falsely implicated in this case. Same Caesar list, all these things in the NDPS FIR.
Page 14 and page
19. Right. Same Caesar list, same thing. On the same night.
You run a jewelry shop or something?
Yeah, no, the allegation that he has made a theft on the jewelry shop. That's the allegation.
Acha.
Later, he was tagged in this NDPS case, but primarily it is a case under 379. On the same night.
Same line from different places? Or you are recovered with gaja while stealing the gold?
Yes, that's the allegation.
What did you do to the police officer?
No, Lordship. Yes.
Yes. He was going to steal gold with gaja on him. He should be in the films.
My lord, another thing.
So that he can.
No, another thing, yes. What other thing?
He was sitting in the front seat. It has been stated 3 other persons straight away who are sitting.
Now in the front seat. Now he's admitting the other position.
No, that's just.
You are in the front seat of the vehicle, not driving.
It has been stated in
the driver has also fled. Or you are driving? You are driving.
He was in the front seat.
Front seat, there may be driver, non-driver.
Driver or not driver, but other 3 persons who have fled, it is in the FIR.
His driving license.
So with Gaja, he was going to steal there's not plausible, my lord.
Why not?
May lordship.
Yes. You're becoming creative by the day. I mean, not you, your client.
Yes. Not my client.
Your client.
The state.
Yes, what happened? How?
Actually, admittedly, there was a case under section 380, 457, unknown miscreants, it was lodged. Case initiated, lordship. No one was apprehended. Later on that same day, in the evening, during the Naka checking, a vehicle was intercepted by the police. And that vehicle, these stolen articles were found together with the Gaja. Now,
This person was framed.
Arrested against that NDPS case, and after that they were shown arrested in this jewelry theft case.
So this is
Unknown miscreants allegation was regarding jewelry theft.
Lordship.
And this NDPS
Proceeding towards Bihar in a car. That car was intercepted by the police. These articles accidentally found in that car and with the Gaja. With the Gaja. Now they are in possession of the Gaja, and subsequently jail interrogation was done and subsequently shown arrest prayer has been made. He was subsequently arrested in the 380 case. In the NDPS case is the fresh case. There is a first case that was initiated. He was brought under arrest.
if they are going for
He's in custody for how long? I mean, approximately you're in custody for how long?
yes, yeah, my lord. It's for about
There are previous rejections also.
1 year 6 months.
He was rejected.
I have been informed.
No.
Which Mr. Rai? Call him. He'll be an exhibit.
No.
Mr. Rai will be an exhibit in this.
Somewhere, maybe in a different.
No, my lord. No, my lord.
Exhibit fled.
All the stolen articles plus
It's not plausible.
You were there how long?
1 year 6 months, my lord.
1 year 3 months. What is the 6 months? What is the stage of trial?
Not a single witness has been. And if they are going for robbery, all these things, is it plausible they are carrying Gaja?
CSW1 lordship.
They are dealing in narcotics.
Of Bihar, if they are allowed admitted on bail, they will flee away lordship. The trial will the trial will be frustrated.
There may be
the
condition.
entire effort of the investigating agency will be.
No, what is the stage of trial you said?
It is fixed 16/11/2023 fixed for CSW1.
Not a single witness has been. My lord.
How many witnesses?
Framed in June.
How many witnesses in total? How many witnesses in total? Do you have the list?
16 witnesses.
16.
Lordship, it will not take more than 6 months.
On any condition, my lord.
Lordship, if they are at this stage, if they are allowed to go, lordship, the trial will be frustrated. The entire investigating agency will.
On any condition.
In this
on
case,
any condition, there may be
opposing lordship.
There may be Thana Hajira on any condition.
No, there is
This is lordship.
we also apprehend will be fleeing to Bihar in this.
This not going to happen. This not going to happen. There may be local security. There may be Thana Hajira, anything.
Our entire.
We are refusing here. Learned counsel for the petitioner argues that the petitioner was framed in different charges of different nature. Full stop, next para. Whereas allegations have been leveled against the petitioner, those are not credible, it is submitted. Full stop, in the same night, it has been alleged that the petitioner was found with contraband.
The afternoon, I think it is around 5.
Contraband articles on him beyond the commercial quantity, as well as the petitioner has been alleged to have committed burglary regarding ornaments. Full stop, next para. More incredibly, it is argued, the other passengers of the vehicle which was being driven by the petitioner had allegedly fled. Full stop. Further, the petitioner is already in custody for more than 1 year and 1 year and 6 months and seeks release on bail. Full stop, next para. Learned counsel for the state opposes the prayer for bail and submits that the petitioner is a resident of Bihar and there is full opportunity, there is a high opportunity of the petitioner fleeing the state, in the event released on bail, full stop. It is argued that the petitioner was found with contraband articles beyond commercial quantity on the day, on the concerned day. Full stop. Subsequently, the petitioner was also found to be guilty of the incident of burglary. Full stop, next para. Whatever might be the merits of the petitioner's case, comma, it would be premature to decide the same at this juncture. Full stop. However, comma, from the circumstances of the case, comma, since the trial of since the trial has already begun, comma, and keeping in view the fact that the petitioner might reasonably be apprehended to flee the state if enlarged on bail, comma, we are not inclined to grant bail at this point of time. Full stop. Accordingly, CRM NDPS 655 of 2023 is dismissed. Full stop. However, comma, the trial court shall expeditiously dispose of the trial against the petitioner, comma, positively within 6 months, preferably within 6 months from date. Thank you. We will be rising and sitting singly after 10 minutes.
Since the division bench which earlier heard this, Honorable Justice Kapoor was a part of the division bench. So if Milord can take, yes.
Lots of one civil revision, your lordships.
My lord, this is an application under section 11 of the Arbitration and Conciliation Act. My lord, at the outset, I must fairly submit. Yes, my lord. Yes, my lord. Yes. My lord, at the outset, I must fairly submit that the agreement is an unregistered one, unregistered and unstamped one. So after the recent. Yes, my lord.
After the 5 years.
Yes, my lord. The petition is accompanying the original agreement. Kindly.
Notice on the other side.
Yes, my lord. This is the affidavit of service. It has been returned, refused, my lord. Yes, ma'am.
You have stopped and all.
Yes, my lord. There's it's against a company.
Oh, they are the director.
Yes, ma'am.
The agreement is for?
It's for transfer of leasehold rights. The nomenclature is agreement for sale, but effectually it's an agreement for transfer of leasehold rights.
Transfer?
Leasehold rights.
Leasehold. So should I direct it to be impounded?
Yes,
To
my lord.
save time and-
Yes, yes, ma'am. Yes, ma'am.
Very good. Should I record your submission on that?
Yes, ma'am. Sir.
Fair enough. Learned counsel for the petitioner, in his usual fairness, submits that although the application is one for appointment of arbitrator under section 11 within bracket 6 of the Arbitration and Conciliation Act 1996, in view of there being some doubt as to whether the agreement is required, is properly stamped, the court may look into the same for the purpose of impoundment. So next para, a glance at the agreement in question, which contains an arbitration clause, which is the genesis of the present application, it transpires that the same has been captioned as agreement for sale and also contains and also envisages certain rights to be transferred, which be that as it may, since it is rightly pointed out that the same is apparently stamped insufficiently, the agreement is required to be sent for being impounded, hence, let the agreement be sent for impoundment to the concerned collector for the purpose of assessing the correct stamp duty, and upon such impoundment taking place, the document, the document be returned to this court for the purpose of passing necessary orders in the application under section 11 within bracket 6 of the Arbitration Conciliation Act 1996. The collector shall act on the server copy of this order, coupled with a written communication by the learned advocate on record for the petitioner for the purpose of impounding the said agreement. The original of this, you have the original.
No, my lord, it's accompanying the petition. Because that judgment also specifies that.
It's not the original.
No, my lord, it should be attached in the end of the application.
Oh, right.
Yes.
For such purpose, let the file be sent by the registry to the concerned collector, who will undertake the exercise of impoundment and indicate to the petitioner the correct amount of stamp duty to be paid, upon such assessment being made. It is expected that the entire exercise shall be concluded by the concerned collector as expeditiously as possible, positively within 1 month from date. Next para, liberty to the petitioner, to the parties to mention for inclusion before the appropriate bench having determination after such exercise of impoundment is over.
My lord, one indulgence, may it be kindly specified that the collector would be Collector Darjeeling, my lord.
Collector Darjeeling.
Collector Darjeeling.
Concerned collector তিন জায়গায় বলেছি, এখান থেকে control find করে the collector, Darjeeling.
My lord.
You just communicate this order coupled with the server copy, and this will be sent by the registry to the collector.
My lord. Certainly. Deeply.
Thanks.